When last we had adjourned, Advocate Mpofu was in the middle of cross-examining Mr. Sithole. There was an aspect which I had not dealt with in Mr. Sithole's evidence, which related to the question of the judgments and orders that had occurred in relation to the PP's office and the question of legal costs. Now, by agreement with Advocate Mpofu, we agreed that that would stand over and the question of legal costs. Either when Advocate van der Merwe, who's the senior legal manager, came to give evidence, or it might be better, and by agreement with Advocate Mpofu, because Mr. Sithole is the one who assisted us to a large part in drafting it, and people may have questions in relation to that. I'm going to put this up in a summary and explain it to the members, so that if Advocate Mpofu has any issues he wants to raise in cross-examination, then that can then be raised by him at that stage. I will give you some of the costs, not all. We just having to verify some numbers, and the remaining case costs I would then provide you when Advocate van der Merwe comes and gives evidence. Chair, if I could then ask Shepo to put up the summary of judgments and orders which is there. In putting it up, are you losing the color coding, or is it too light? Can you just go down? Let me just check on mine. Okay, it might just be a bit light. And if I could just take you through the 5 different folders to give an explanation. One of the issues that comes up in the context of the motion is the question of legal costs that are incurred under paragraph 11 of the motion. One sees that appearing, and the question of how that is managed. In fact, let me give you the exact Advocate Nkubani has committed misconduct by and or demonstrated incompetence in the performance of her duties by failing intentionally or in a grossly negligent manner to prevent fruitless and wasteful and or unauthorized public expenditure in legal costs. And we would see from the, and these are essentially a summary of the judgments during the period of her being in office. So if we take it, and I'm going to start from the back going forward. If Shepo, if you could go to the folder 5, right? These are the cases in respect of which, can you make the document a little bit smaller so that the whole document can appear on the screen? Oh, it is, okay, right, sorry, right. So if you go to the top of the document, right, you're at number 30, go up. There we go, right. These are the cases which would have finished off during the period of Advocate Nkubani's term of office, in respect of which had commenced when Advocate Madunsela had been in office. And so what we've done with the color coding and to assist you when you do your deliberations is that effectively where it's coded in bright yellow, right, then the public protector has been successful in the case. In the last column, you see a figure. For example, in the top right-hand margin, it says 334,531.37. That is the amount of funds that on a bill of costs would have reverted back to the public protector's office as cost which they earn or which is recovered from the litigation. You will see that it tells you who the attorneys are engaged in the matter at the time of litigation. Sometimes there has been prior attorneys engaged, which wouldn't necessarily be reflected, but these are the ones on record. So if you go down, you would see, just scroll down. These are all cases. Shippo, just goes down slowly. Right. I want you to go to number 30, I think. Actually, let me pull mine up so I can follow with you. Right. Go to number 18, 19 of the cases. So all the ones in yellow is the ones that's been successful that had commenced under Advocate Mkhubane. From number 19, right, you will go down number 19 and 20. There are two cases in which that had been lost and cost was ordered to be paid to different degrees at the Public Protector's Office. If you go on to 21, it's still that. Go down to 22. Numbers 22, 23, and 24 are cases that had been dismissed, but there had been no order as to costs. All right. Number 26, 27, and 28 do not relate to reviews of reports that had occurred. All right. Number 29, 30, and 31. You will recall that Advocate Mr. Sithole gave evidence last week of a list of cases in which the current public protector took a decision that the notices to withdraw, that the notices to oppose will be withdrawn. Those included 3 matters that had commenced under Advocate Madantsala's period when related to reviews of the state capture report and 1 to the secure in comfort report. Those matters have to date not been finalized. The litigants have not done anything in furtherance of that litigation, and the public protector has not opposed it. So it's just been lying there, although Mr. Sithole says that in the one matter that it has reached an application for leave to appeal to the SCA has been refused, but there is still other applications pending. And then the last 2 matters are matters not of a review nature, which is 32 and 33, which is still pending. Right? Now, if we go to number 1, number 1 are the cases under Advocate Mkhubane, and they've been grouped together in relation to dealing with primarily the same kind of cases. So number 1 would be what we would know as the CR17 matter in the Constitutional Court and in the Gauteng High Court would be 1 and 2. You would see that in the cost column, if the block is not yellow, then the costs have either been not ordered by the court, no cost, which is what the Constitutional Court did, and then the other cost is either for the account of the public protector. From number 3, you will see the litigation. I think you must make the screen a bit smaller so that the last column can come in. Yeah. Number 3 relates to the litigation in the Absa Bank Reserve Bank CX report, right? And you will see by number 5, there's an item in red which says there was a court order, or the bill was taxed in the amount of 1,510,812 rand and some small change, which is what the public protector had to pay in costs to Absa Bank, of which amount the 15%, which the High Court had ordered and the Constitutional Court confirmed was for the account of Advocate Mkhubane, was in the amount of 226,621. And the Gordam cases starts at number 7, and they go down until number 18. Those are the cases dealing with the pensions and the cases dealing with the either relating to the IGI reports disclosure as interlocutories or the litigation in relation to the EMEA and SARS unit to go down. At number 19 are the cases relating to the Vrede Dairy, and you will see that at number 20 is the, in blue, the cost order that is made against Advocate Mkhubane. That goes down. The figures in red reflect the untaxed bills that have been submitted, which still have to be taxed and to be paid in this matter. From 24 onwards, it's the challenge to the subpoena powers of the public protector. You will see that in the High Court, there was a personal cost order made against Advocate Mkhubane. That was overturned by the Constitutional Court in respect of the cost, but the matter was lost on the merits. From 27 onwards is the case dealing with the erstwhile Premier Zille and the tweets, which the SCA had ruled against the Public Protector's Office with costs, right? Then from paragraph 30 is the matter of the erstwhile Minister of Water and Sanitation in Quinty. That was the subject matter of Ms. Baloy's evidence. It's one of the reports that she testified had been quality assured by her, and in which the allegations were made that the previous CEO, Mr. Mashlangu, had interfered in. That report has withstood scrutiny at the courts and has the application for leave to appeal at the SCA was dismissed with costs in May 2022. Then from number 34 onwards are various reports that have been reviewed and set aside either with cost orders or where there has been an order of no cost. That takes you up to number 56. At number 56 and number 57 are essentially two cases where the reports were not set aside fully and costs were ordered or by agreement, costs were made in favor of the Public Protector's Office, right? If you go down, you will see that in the following from 59 onwards, reports are set aside without any order as to costs. And you will see that where there's a turquoise color of legal services, it is because there is no external attorneys engaged in the matter. Mr. Sithole's department effectively dealt with the matters in that regard. I then take you to number 73, right down to number 97. those are cases that are, the reviews of those reports are pending before the High Court. They have not been opposed by the Public Protector's Office. I'll give you the total numbers in a bit, right? So, so there are a number of cases or reports, the review of which is pending before the High Court, and there's been no opposition to that review. I then want to go to number 3 on the folder. Number 3 on the folder, the first 3 items, go to the top, Sithole. The first 3 items relate to 3 matters that are pending in appeal level. The first one is a judgment on the application for leave to appeal in one of the Gordon matters that we're still waiting on a ruling from the Constitutional Court. The other one, the PP's office has just gotten leave to appeal very recently. And the third one is the Muntu matter. From number 4 onwards is reviews of reports pending at the High Court that are being opposed. They are either being opposed with external attorneys having been appointed with counsel, or they are being opposed from number 10 onwards, where the external attorneys have to date not yet been appointed, but are still being dealt with by the internal legal services to varying degrees. You will then see, if you go down to after 27, that there are 6 matters which are not related to reviews of reports, which are also pending before the courts. The first one is the perjury charges that have been brought against the public protector. The number 3 we've dealt with in evidence of Mr. Samuel. It's a claim for the 350,000 that's there. And then there is numbers 4, 5, and 6 are other civil matters. All right. Those are also pending. Now, if you go to number 4, those are matters which do not relate to the review of reports. And if you go to the top, you would be familiar with number 1, 2, and 3 relate to the Baloy challenge, which she had won at the Constitutional Court, and it's referred back. Numbers and then the other matters on this list are not related to essentially reviews of reports. If you come to where they are again, where they highlighted in yellow, the public protector, scroll down, Sithole. If you see, like, for example, numbers 14, 15, 16, and 17, it's where the Public Protector's Office has been successful and have been the recipients of cost awards. Now, if we go to number 2, which is called own initiated litigation, this essentially relates to the number of judgments pertaining to either the challenge to the rules of the National Assembly and the various cases dealing with that. And if you go down, there is one, number 1 is the judgment which is still pending before the Western Cape High Court. The others are the cases that have been completed in relation to either a challenge to the rules interdicting the president or the challenges to interdict this committee from proceeding. So those are what number 2 is all about, which is the 10 items listed there. Now, in total, what does this amount to in respect of reports? We know, and I'll ask Mr. Sithole to confirm in a moment or disagree with anything that I've put to you right now, but we know that during the period in question.
Just a pause. We see that the public protector and their legal team You have lost connection. We just wait for a minute so that they follow you. If you can just pause.
You start with the
Are you back, Advocate Mpofu?
Yes,
you
good morning, Chair, and everyone.
Are you back? You just lost connection.
Checked completely.
You are muted. You are muted.
Oh, sorry. Can you hear me now, Chair?
Okay. Yes, I can hear you now.
Yes, yes. Good morning, everyone. Yeah, we lost contact completely, so we are reconnecting through a different device. Unfortunately, I don't know how much we've lost. I think it was at the point when Ms. Bauer was dealing with the case in the Concord and referring to Ms. Baloyi.
Oh. Okay, thank you. Yeah, we recognize that we did pick that up and then we pause for a minute or two.
Okay, thanks, Chair. Yeah, I just don't know how far back that is. I think it was approximately around that time of the Concord case.
We will ask her to just repeat from where
Yeah.
you would have lost us. Thank you for that.
Through you, Chair, I simply pointed out that the items in the fourth schedule related to non-review related matters in that regard. And then I went on to those in folder 2, effectively saying the first one was the judgment still pending at the Western Cape High Court, and the others which has been referred to is the cases relating to the challenge to the National Assembly's rules, the interdict sought, and the challenge to this committee. And the part I was going to turn to in respect of reports and was the following. During a period of inception up until the end of the financial year, 412 reports were produced as reflected, and I exclude the 6 months period that Advocate Madinsala was in office of the first financial year. So the PP's office could indicate from taking office in October of 2016 to date, to the end of the financial year 2022, 412 formal reports were produced. Of that, 36 have been reviewed and set aside. 37, sorry, one of which is a closing report. And there are 47 pending before the High Courts. And that's in summary what we've reflected on the schedule. And maybe to deal with that, we would also know from the reports that we have and from earlier evidence that has been given is that in the annual financial statements and the total cost from the financial year of 2016-17 to the end of 2022 for what was called professional and consulting fees for that period of time came to 158,976,155. Those figures are reflected on Annex NM 17 to Advocate van der Merwe's affidavit.
For which year?
Of in NM 17 of Advocate van der Merwe's affidavit.
2022. Yeah.
Of he has included the 2015-2016 year. And if you exclude the 2015-2016 year, then there's a revised NM 17 on the file. Let's go to it. There is a revised one that I've put into the folder to reflect it. Of the 158,976,150 that has been spent, 146,998,047 has been spent on legal fees. And what I'm going to endeavor to do is break down what the biggest cost drivers of the 146 million has been. And I'm going to deal with 3 today and deal with the others later because we're just trying to confirm the figures. Right? The category in relation to the ABSA CX matter, which forms the subject matter of this motion. If one includes the litigation cost, the tax bill, and 2 opinions that had been obtained subsequent to the judgment of the Constitutional Court handed down, then the total bill in the ABSA litigation came to 14,537,728 rand and 26 cents. To do that. Right. The total cost of the litigation in respect of the DA Cassack matter, which so maybe I must also preface the ABSA matter to say it involved the employment of 6 different law firms and several senior and junior counsel in respect of different times and of the matter. In the DA Cassack matters before the High Court, there was, and then there was subsequent appeals that failed right up to the Constitutional Court, as well as in opinion obtained in respect of the interpretation of the court order. That came to 5,666,206, 5,666,206,087 cents. Right? And then the litigation, which involves the challenge to the rules, representations to the Portfolio Committee, and the litigation against the National Assembly and other parties up until the end of the financial year had come to 15,023,585 and 63 cents. Now, what I will do by next week is we will break it down and show what the other big drivers were that comprise of the 146 million. Mr. Sithole, are you there?
Morning. Can you hear me?
Good morning, Mr. Sithole.
Morning,
Just-
Chair
just-
and members.
Just try and fix and reposition. We don't see your head, so it's a headless Sithole. Now we can see. Well
Thank you,
shaped. Welcome back, Mr. Tempungo Sithole.
Thank you, Chair, and morning to you and members.
Thank you. Just a pause. I see a hand, Honorable Mailam.
Thank you, Chairperson. Chairperson, I'm sorry to interrupt. Advocate Bauer indicated that she'd come back with a breakdown next. And I wonder if we could just get, as part of that breakdown, a breakdown of which firms of attorneys and which advocates benefited in each case to that extent, because there may be some questions around that. Thank you, Chair.
Thank you, Honorable Myla. Advocate Bauer.
Yes, that is. I hear you, Mr. Milam. We will endeavour to assist the committee. Can I maybe suggest the following? That if it's under $1 million, that we do not be put to the trouble of having to do that.
Yeah,
that
we don't hear you. Just speak through the chair.
Sorry, through the chair. I'm suggesting that if it relates to under $1 million, that we have some sort of a cap on it, just to minimize to put this together. Mr. Sithole can confirm we have been at it for weeks to be able to disseminate it in a manner that the committee can readily understand how it works. And Mr. Sithole has put quite a bit of work into assisting us in getting this to this point.
Thank you, Advocate Bauer, for reminding. Maybe before I do that, I recognize Honorable Heron.
Thank you, Chair. Chair, I have no problem with the request. I think we must just be careful by saying which firms and advocates benefited, as if they didn't do any work.
Yeah.
I think that's wrong.
Yeah.
Secondly, if I can just, before we get into the evidence, I wanted to understand that the first sheet in the spreadsheet, that those matters were reports that were done under Advocate Madonsela, completed by Advocate Madonsela, but the litigation was concluded and run after her term of office ended. Is that correct? Or are some of those matters that started with Advocate Madonsela's term and completed with Advocate Nkobane? I just want to see if it's clearly Advocate Madonsela's term's work that has been challenged.
So the litigation all, or for the most part, commenced during Advocate Madonsela's term and was pending at the time, and Advocate Nkobane came in. I think in one instance it may very well have been a judgment that still had to be handed down in doing that. So one finds that that is there. Where the end date of the judgment falls post-October, and it related to a cost implication that may very well have fallen into Advocate Nkobane's term. What I'd like to put is a globular figure to the committee of these were cases that had commenced during the period of Advocate Madonsela, but the costs were incurred out of the 148 million rand budget of Advocate Nkobane. If you understand what I'm saying.
I think I think I understand you. I just want to be clear that the report would also have been Advocate Madonsela's terms report.
That's correct. From what I can understand and see, there are only 2 or 3 reports of Advocate Madonsela's term that had been set aside during the period of Advocate Nkobane.
Okay, thank you, Advocate Bauer. Thank you, Mr. Heron, also for that intervention. So the language has to be a proper one. It's all of those involved, so that we don't confine ourselves to a particular narrative. Mr. Tembungo Sithole, I just want to remind you that you're still under oath. And so as we continue, because we had paused with you the last time, so welcome back. We want to continue. I hand over to Advocate Bauer.
Mr. Sithole, I'm going to be very brief with you.
Maybe
before we go on with this, particularly in relation to the issue, and want to thank Honorable Heron for that intervention. I just want to put certain things on the record here. One is that this evidence already, I think, is skirting on invading people's privacy unnecessarily, and I think maybe it should be confined to those who are targeted, so to speak. So, like some of us, we don't mind the information being put up there. But I think that people who have rendered professional.
Just pause. Mr. Sithole, can you in the meantime just mute? Mr. Sithole? Just mute in the meantime.
He's muted now.
There was an echo. Can you continue? Because we're trying to address an echo. Continue, Advocate Mbofu.
Thank you, Chairperson. Yeah. Well, I'm saying that I'm saying two things. One is that there seems to be some zeal to invade people's financial and personal issues, particularly some of the professionals whose names have been listed. So, for example, if it is said that there was, I can't remember the figure now, 14 million or whatever it is on the CX, then someone is going to then go and look at, then it was Advocate Smith or whatever who did that matter. And then according to the narrative that is now being peddled, that person quote unquote benefited. And it's wrong for two reasons. One, because it's there's no, apart from sensationalism, there's no value to be derived from it by this committee, unless if one is going to drill down into what happened in a particular case and was there an appeal, was there no appeal. To just flight numbers like this is really can only be directed at the appetite of those who just want sensationalism. So that's the first thing. The second thing is that this entire thing is actually unwarranted because the charge that Ms. Bauer spoke about, which relates to so-called expenditure in legal affairs, did not even, there was no prima facie evidence of that according to the independent panel. I know that I've raised that at a broader level, but I'm raising it now specifically to show that you're just invading people's privacy for no gain at all, because this is completely not relevant to any charge that is before you. And the only matter in respect of which there was any reference to that charge was the GEMS matter, which has not even been dealt with here. So that's the point. I'm just simply saying that if it is found, which I'm sure it will be at some stage, that you have to deal with the matter according to the independent panel report's findings, then all this will just be completely, as I say, an unwarranted, completely unwarranted invasion, because you won't be able to undo the damage that you might have done to innocent people and professionals who would have rendered their services. As I say, I mean, and those who can't speak for themselves, those who are here like me can volunteer to say you can reveal whatever you want to reveal. But other people who really, all they did was simply to render a service for a client, and now are going to be told that they benefited 14 million or whatever total amounts, which is also a lie, because and as I say, until somebody can break it down into its constituent parts, there's a difference between a case that ends up in the magistrate court and one that goes right up to the constitutional court. But all those details are not dealt with in this sensationalist way of dealing with this matter. So I'm really saying, Chairperson, that I mean, I know Parliament is immune and all that, but it doesn't mean that power must be abused or that people's rights who must be abused by being associated with something that, as I say, completely has nothing to do with the work of this committee. Because A, it's irrelevant, but B, the harm far exceeds, the potential harm to others far exceeds any gain. Well, that's easy because the gain is zero in the sense that this has nothing to do with the work that you have to deal with. How you handle it going forward is up to you, Chair, but we just don't want to be seen to be playing along with this complete invasion and of people's privacy, which is in vain, totally in vain. Yeah. And it has started already by the kind of language which, thank you, Chair, you have at least assisted in intervening to deal with. And we know where it's all going, but you know, some people can take it and others can't. And we are, those of us who are here can take it, but others might not be and shouldn't be put through that actually. Yeah. Okay.
Thank you.
You can only do that to hardened horses like us. Yeah. Not
we are Galak.
Okay.
We are Galak.
Sorry,
Advocate Bauer. And
no, we can take it.
Honorable Ngol.
So I have two things to say. I'm not going to repeat this, what we have said previously about our view on the prima facie findings of the independent panel and its role. I dealt with that in the opening address and I don't see any point of it. I also prefaced the schedule in saying that the name of the attorney and the counsel on the schedule of the litigation matter did not necessarily reflect that they had dealt with the matter throughout. I said that. I made the point in the ABSA matter of saying that 6 attorneys' firms and several counsel had been engaged. To the extent that there's a inference being drawn that the schedule can necessarily correlate to the funds, I made it quite clear what was reflected on the schedule with what was on record on the judgment of that. For example, a good example is that the attorney's firm who may be on record in the ABSA CX matter only went to note the judgment necessarily and didn't have anything to do with the litigation as an example, so they wouldn't be party to that. So the two things don't necessarily read to each other in doing that. And so if there's an inference of us trying to reflect something on the schedule of judgments, that was not the purpose being sought.
Okay, thank you. Honorable Mwala, before we proceed.
Thank you very much.
So I'm sorry, Mr. Honorable Mwala. I just wanted to put something maybe before you respond, a very quick one.
Okay, go ahead.
With the permission of the chair, of course. Please, Chair.
Go ahead.
Thank you, Chair. Yes. Yeah. Thank you, Honorable Mwala. Yeah. No, yeah. Sorry, I just forgot to mention one of the issues here that makes this whole exercise completely unfair. I accept what Advocate Bauer is saying about all the qualifications that she made at the beginning. Yeah, but that's not how it works in the real world, and she knows it. Yeah. Those associations are going to be made and nobody's going to say subject to this, subject to that. I mean, anyone who lives in South Africa knows how the media and its assistants all over the show operate. Now, I'm saying that one of the key unfairnesses, Chair, which you need to consider, which I forgot to mention, is the following: that we get already here, we get a skewed picture just on the way this thing is being presented. I'll give an example on something that I know directly. You are told that in the litigation to do with the rules, X amount, and I've forgotten the amount, has been spent. But nobody says what has been spent by Parliament and the President and the DA and all those other people who were involved in that litigation. One. Two, what was the benefit? And here the word benefit actually applies. And what was the outcome? We've discussed this in a different context, that, for example, that matter has resulted in us being here, all of us being here now. And whether that's a good thing or a bad thing depends where you sit. And so unless the context is put into the matter as to who did what, I mean, an example in that matter is that at a particular point, it would have stopped, but Parliament and the DA decided to appeal. So where do you factor all those things in if you don't give the full picture? I'm just using that as an example because I was involved in it. Yeah. But for the other counsel who are not here, they won't be able to give you that perspective. I'm giving it because I was involved in that matter. And so they will just be, painted with a brush of having abuse. Remember this, the charge that Advocate Bauer refers to fruitless and wasteful expenditure. So already you are associating people with that kind of negativity. As I say, for no particular benefit at all, except to put their names on national television for when they are innocent. Yeah, it's a very serious issue, Chair. I really would like it to be addressed in the seriousness that I'm raising it. We've tried to discuss it with the other side, or rather with the evidence leaders, so that it is done in a sensitive way without obviously curtailing whatever work they have to do. Thank you, Chair.
Thank you, Advocate Mpofu. Honorable Ngola.
Thank you very much, Chairperson. Chair, I think to make things easy, let's replace the word attorneys and counsels that have benefited by attorneys and counsels that have rendered services.
We can't hear you, Honorable Ngola.
Can you hear me now, Chair?
Much better.
Yes, Chair. I'm saying, Chair, maybe let's...
We can see you've got a new equipment, so test it with us. I test a bit.
No, Chair, I was saying, I hope you can hear me now.
Reposition and make sure that whatever mic you have comes closer to you, yes, so that we can hear you.
Can you hear me now, Chair?
That's much better. Now you know how to use your new equipment.
Thank you, Chair. No, Chair, I was actually suggesting that let's rather use the word attorneys and counsels who rendered services. Of course, I agree with the conviction that the benefited part would seem otherwise. It would create a very conflicting narrative to the public. The second issue, Chair, that I wanted to venture in is an issue that relates to the sketch that actually shows that there are these law firms, that these counsels who have rendered services, and this is how much they costed the public protector's office. In my view, Chair, there is nothing private about public funds that were used in advancement of the obligation that is placed upon the public protector's office. In my view, we are not, the proposal in how I see it does not say, let us go to the accounts of those law firms. It says, let us reveal that these are the services that were rendered by Xola Ngola Incorporated attorneys. and this is how much that service costed the public protector's office. I think that's how I take it. Moreover than that, Advocate Mpofu is raising a very critical question here, which is the fact that what value will that information add into the obligation placed upon this particular inquiry? In my view, it will add a serious value, because there are a number of 2 or 3 witnesses that came here in this inquiry that spoken about issues of legal services being rendered in a way they did not understand, such that someone even said the public protector chopped and changed attorneys and counsels in brief and all those things. So those things were said in the public domain here in these proceedings. So I think it will be correct for us to understand and get that particular evidence, so that we're able to whether confirm or not confirm what has been accused by some of the witnesses towards the office of the public protector. And we remember, Chair, that the directives actually allow us to lead evidence in respect of what a particular witness actually came and testified into the inquiry. Thank you very much, Chair. I wanted to just to add that.
Okay, thank you. I want to just wrap this up and give a ruling. I see, Advocate Mpofu, you have your hand up again?
No, Chair, sorry, it's an old hand. I'll take it out.
Okay, it's an old black hand. Thank you.
Yes.
No, thanks, Honorable Nola, but I also want to acknowledge Advocate Mpofu to say, I think you're putting me on alert on 2 issues, which I respect and going to adhere to. It's important for the process. So you're putting me on alert so that we're on the watch on the issues of invasion, on private financial issues. We have raised the issue of privacy here a number of times. So I welcome and accept that. Secondly, the fact that we have immunity, that we don't abuse that. So I take that too. I think at this stage, with that alert that I have, having to go through and watch this, I do agree with Honorable Mola that at this stage, we will be, because what is important, what gets to be placed here, it's important to assist all of us. What I will be ensuring that doesn't happen, that there is no kind of a narrative that begins to demonstrate a certain narrative, which is not part of what we're here for. So I think with that, I'm going to be asking that we proceed, and that I will be intervening at any point where I feel we're getting into those areas that you have identified, Advocate Mpofu. Advocate Bauer?
Could I, through the chair, then revert back to Mr. Sithole?
That's what I'm asking you to do. Thank you.
Mr. Sithole, can you unmute?
I'm unmuted.
Mr. Sithole, you had been integrally involved in most of the information that's contained in the summary of judgments and orders was obtained through yourself, correct?
Correct.
And you confirm the correctness thereof?
Correct.
You've also heard the narrative that I've sought to explain to the committee. Do you agree with the accuracy of what was relayed to the committee in respect of the schedule?
Yes.
In respect of the question of legal costs, you actually have a more comprehensive summary, and does the totals which I put before the committee accord with with your information as to the cost incurred in the cases to which I've referred?
Yes, as received from our finance department, yes.
Yes, in doing that. And you've also verified the number of reports in respect of which we indicated have been reviewed and set aside, and those that are pending, both opposed and unopposed. Correct?
Correct.
Chair, that was what we had sought to lead on. There is now, Mr. Sithole will assist or come back when Mr. van der Merwe gives evidence on this aspect in the event there are any further questions arising on the question of fees. Mr. van der Merwe is recently appointed as the senior legal manager. Mr. Sithole has been there through most of the incurrence of the fees, say for the first 2 financial years. He was not in the legal department, but has extensive knowledge on that.
Okay, thank you, Advocate Bauer. With that, we then step off and go back to Advocate Mpofu. We had paused you on the day with Mr. Sithole. May I now recognize you to continue the cross-examinations with Mr. Sithole?
Yes. Thank you, Chair.
Advocate Mpofu.
Thank you, Chair.
Yeah. I see that, and this time around we can't say he must mute because both of you are going to be interacting. I also want you perhaps to just reposition yourself properly, because unlike before, we can't hear you properly unless you are now fading. So
No.
maybe we can take a.
No, it's because I'm using a device that belongs to the public service.
It's difficult for us to hear you properly with your 25 years of whatever in the background. There's a background there of your 25 years. I don't know of who.
No, Chair. No, I was saying.
Okay, we will take 10 minutes break so that you fix whatever you can fix.
Yeah,
and be back after 10 minutes. Will that be in order?
Yes, that will help because I can bring back my own device, not this one.
No problem.
Yeah, I must buy you some new devices.
But not any other thing. Thank you. 10-minute break.
I must
Recording
sponsor
stopped.
with some new devices.
Okay. You will be back at 12:30. Thank you.
Terrible. Thank you.
I hope that we have everything sorted out with Advocate Mpofu. I see you are now back on your gadget. Maybe before I go back to you, I just want to recognize Advocate Bauer.
Through you, Chair, I may have been very precipitous and naive in answering the Honourable Member Milam and suggesting we have a cap of $1 million. I want to readjust that to say a cap of 2 million, because in the context of $1 million, we're going to pick up a whole lot of smaller matters which wouldn't be of necessary relevance to the question that you want to be answered, if that is in order.
Okay, thank you. Advocate Mpofu, back to you.
Yes, that echo is still there. I honestly don't know. I don't think it comes from Mr. Sithole. I think it comes from somewhere else. Mr. Sithole, maybe if you can mute.
I can confirm that it doesn't come from my side.
Yes.
Okay, and it doesn't come from Advocate Mpofu either.
No, it doesn't. It's probably Honorable.
But we can, let's try. We can hear you better now, Advocate Mpofu. The platform is yours.
Thank you, Chair. Thank you, Chair. Okay, Mr. Sithole, I'll try and speak up and compete with that noise when it comes. Good morning.
Morning, Advocate Mpofu.
Thank you. I think let's start here. With this, you saw the exchange that happened this morning. We'll come back to it. I just want to ask you a few broad questions. Yeah. You are a qualified attorney, correct?
Correct.
According to your statement, you were at the PP's office around about 2013, 2014, and then you left to go and do your articles, correct?
Correct.
And then you came back in 2017, correct?
Correct.
Right. So at least as someone who has been in private practice, you might be able to clear the air on some of the issues that we raised this morning. So that's the one side. The other side is that you have worked in the you have worked in the legal services space at the PP's office. Yes, Chair.
Just so that you are not disturbed, because I think this echo is disturbing you. Mr. Muntu, can you try and lower your volume in your system, because it's really disturbing. You can't even conclude a question because it gets into your way.
Yeah, I think that's a good idea. Maybe I'll also do the same.
Now you're much better. Let's see if it is muted now, but we don't want him to be muted because he must answer the questions. Unmute Mr. Muntu and see how it works.
Yeah, look, if it comes to a push, we'll have to mute when we're not speaking, you and me. Let's try to avoid that. I think the chair is right. It might actually disturb you from answering questions.
Go ahead, Advocate Mpofu.
Thank you, Chair. No, I was saying, Mr. Sithole, that I'm now looking at the other side of the coin, which is your work at the Public Protector's Office. There, you have mainly been in the legal services department, correct?
Correct.
And at some stage, when your boss, whoever it was at that time, had resigned, when there was a vacancy, you were basically in charge of the issues that we're discussing here, the payments of persons, the briefings, and so on, correct?
Correct.
Right. Now, you would agree with me, firstly, that, you know, they say in law, context is everything, that it is important to put some of the information that was put to you in its proper context, correct?
Correct.
And to your knowledge, the professionals whose names have been bandied about here or have been put up, did they render? I mean, can exclude me for that. Did they, just my colleagues whose names have been put up, did they render professional services as required?
Yes, correct.
Did you have any occasion to ever think that the expenditure that was used on them was wasteful and fruitless?
No.
Thank you. All right. Now, there was an example that was given to you the last time we were here, I think it was 2 weeks ago, which might also assist in this. You remember you were asked about one of the narratives in this thing, in this committee is has to do, for example, with the change of counsel in the CX matter, I think. You remember that whole debate?
Yes.
Yes.
Yeah.
Now, you put it into proper perspective because you said that at a particular point, the senior counsel who was in charge at that point made a request to you as legal services to say, I would like this other aspect to be handled by another team or by another silk, correct?
Correct. That's
It was
the
Friday. It was Friday. Yes, yes, yeah,
Yeah.
it was Friday. I'm just avoiding to call the name of the council. Yeah. But and then that person who was in charge of that case indicated to your team that they needed the services of a separate team for a particular aspect, correct?
That's correct.
And I think your indication was that at that stage, the actual hearing date was around the corner. I can't remember the period, but it was not far off, correct?
That's correct.
And if you had said no to that counsel who had done a lot of work on the matter at that stage, and the hearing was around the corner, and you said no, we are refusing to your request, what would have happened?
I think we would have run at the risk of not being able to file heads and argue on the Kazakh side, if I'm not mistaken, or the Kazakh review. I can't remember on which he was in between the DA and the Kazakh one.
Yes, I think he remained on the DA and he wanted another team for the Kazakh one, but you are right, it doesn't matter which one. Let's say on the one or the other. And would you also have run the risk of maybe even losing that counsel if you said no to his request?
Yes, that was our view.
Yes, and would that have resulted in fruitless expenditure? Because you'd have had to get 2 new teams or 1 new team for the work against the work that had already been done. Wouldn't that have resulted in fruitless expenditure?
It would have.
Yes. So you see, that's the point. You know, when things are just flighted there without context, it really is doesn't assist anybody. But anyway, and then there's a story this morning that came about 6 attorneys that were used in one matter. I can't remember which one. I think it was CX. Yeah. Again there. Is it a fact that some of those attorneys had voluntarily withdrawn from the matter for whatever various reasons, correct?
On that one, Chair, I will say I only got involved when we engaged the services of PASCAN. And that was when we filed the appeal to the Concord. Leave to appeal and then the Concord application. So I was not involved in CX before that stage when the previous attorneys were changed.
Okay, no, that's fine. All right, but you may or may, fair enough. You may or may not have personal knowledge of this or even second-hand knowledge, but do you know if the change of attorneys in the previous cases, because that will be the evidence of the public protector, which you may or may not be able to confirm, that some of the attorneys had withdrawn and there was nothing that the client could do about that.
Yeah, I think I was told by Nemasisi.
By Mr. Nemasisi. Okay.
Yeah.
Thank you very much. All right. And okay, well, this thing has made me to start where I did not want to start. But let's rather pursue this so that we get it out of the way. This is going to be the evidence of, please listen carefully. Okay, no, I'll do it bit by bit so that I don't overwhelm you. Yeah. The evidence that we're going to lead is going to reveal that there are about 7 ways in which external legal people are engaged. And I'm going to take you through each one of them, and then you can just confirm if whether in your own experience or you've heard of this happening. The first is that it might happen that the attorney is asked to identify counsel. Oh, no, let's start here. The attorneys themselves are appointed according to the panel that is predetermined, correct?
Correct.
And that panel is appointed in terms of your internal procurement measures, correct?
Correct.
Right. Okay, then we go to the next stage. Now the attorney will get identified out of your list of attorneys, let's say attorney X. One of the ways in which you would engage counsel would be for that attorney to identify an advocate of their choice, correct?
Correct.
And in certain instances, the attorney may even come back and ask you to say, okay, I know I've got a right to appoint counsel, but do you have any preferred counsel? So that also used to happen, correct?
Correct.
That would be the second way in which this would be done, or rather that an appointment could be made, correct?
Correct.
And in fact, sorry, just a minute. I just want to take you to an example of that. If you go to page 4033, sorry, 4031.
Of which bundle?
On this bundle, on Muntu's, on Mr. Stoller's statement. It starts at 4011. Yes, if you can go to 4031, that's it's an annex chart, TMS3. Yes, that's the one. Just go back 4030. Yeah, let's start there. That's just an example of the. Just go further down. Yeah. It says. Okay, forget about the name of the attorney. It's just an example of the kind of offer that you would give, Mr. Sithole, correct?
Correct.
And it's called offer of appointment request for provisional legal opinion. And the relevant to what we're discussing now, if you go to paragraph 4 on 4031. Yes, thank you. In this particular case, and as I say, it's just a random case, I just happened to have found it here. In this would fall under what I called example 1, paragraph 4. It says, it is advisable that we instruct a senior counsel who has in-depth knowledge in pension law. This was to do, I think, with the Pillay case, which dealt with pension law. Is that in accordance with your experience?
Yes, that's correct.
Yeah, in other words, in this case, you did not say go to advocate so-and-so. You just said we need someone who has experience in in-depth knowledge of pension law.
Correct.
And then if you go to the next 4033. Further down, paragraph 4. Then you get what I've called the second example, category 2. So what used to be a category 1 case where you are saying the attorney must appoint, then the attorney comes back to you and says, kindly advise whether we must use our discretion to appoint a senior counsel, in other words, category 1, with the necessary experience and expertise, or category 2, whether you have your own preference of counsel to be briefed in this matter. You confirm that?
Yes.
Yes. So that then gave the Public Protector's Office an option, whether this will be a category 1 matter in which you recommend someone, or a category 2 matter in which the attorney has a free hand to brief someone who is averse with that topic, correct?
Correct.
Good. Then category 3 would be where the legal department, and that could be you or Mr. Nomasisi or Mr. Mhlongo or whoever at that point, may identify a preferred counsel and recommend that person, correct?
Correct.
And that would be from your own knowledge as someone who has practiced law. Maybe you know that advocate XYZ once did a case to do with this or the other, and you may recommend that person, correct?
Correct.
Good. Then we come to category 4, and I think it has also featured here, where you might have junior counsel who has come into the matter by whatever means. And that junior counsel may recommend a senior when a matter, say, becomes complicated, and say, I would like to work with senior so-and-so because this matter has now become too complex for me, correct?
Correct.
And that has happened, I think, particularly in the case of the Financial Services Conduct Authority. There was a junior counsel and he recommended a particular senior who was unknown to you, but you hired him because of the recommendation, correct?
Correct.
Then we go to category 5, and I'll own up to this one. It would have happened, for example, in the Pillay matter, which you might remember, where the senior counsel now recommends a particular junior to assist in that particular matter. And that junior might be unknown to you, but you just go along with the recommendation of the silk, correct?
Correct.
Right. And then we come to category 6, where the public protector may also make a recommendation because she knows someone or she has had someone who's good in this or the other. That recommendation would also be channeled through your legal department to the attorney, correct?
Correct.
Yes. And then we had the seventh category, which happened in practice, and I'll deal with it in more detail later, where somebody else in the PP's office, in this case, it would have been the special advisor to the public protector, who was also a lawyer, might also know somebody and recommend that person, and that person get appointed because of particular expertise, correct?
Correct.
Right. Now, so the mere fact that so-and-so was used by a particular attorney can be any of these 7 different, there might even be more, which I don't know about, but at least I've been instructed on these 7 ones. Could be any one of these 7 methods, correct? We can't know just by looking at a name whether it was category 1, category 2, category 3, category 4, category 5, category 6, or category 7, correct?
Correct.
Thank you. Right. Now, we have, there is evidence, because I think this thing was directed at a particular brief. I don't know whether you were already there or it was before your time, but are you aware of the recommendation that was made by Mr. Nyembe in respect of Mr. Ngobeni?
Yes.
Yes, and I don't want to overput it, but there was a letter here that was read in another context that showed that Mr. Nyembe was a big admirer of Advocate Ngobeni's intellectual power. Can you confirm that?
Yes.
Yes, and that you may or may not know this because it was between the public protector and Mr. Nyembe. But one of the reasons for recommending him for a particular task was that, according to Mr. Nyembe, he would bring both the legal expertise, but also he's also a writer in the public space at the same time. Were you aware of that?
Yes, that was Mr. Nyembe's view.
Yes, and indeed, some of the work that he produced had some of it, you could say, had more legal input, but other times it had more of the what you might call the communications input. Correct?
Correct.
And as an example, if I make 2 examples, there was an invoice where he was paired with another advocate. Again, I don't want to mention the name of the person because that person is a judge now. But you might know the case where Mr. Ngobeni had been paired with a practicing advocate at the time. Correct?
Yes.
Yes.
Correct.
And that invoice, because it had more legal input, was paid by your department, correct?
Correct.
And then there's another example which we can take to the other extreme, where it was felt by the legal department that there was more of the communications consultant input than the legal input, and the legal department refused to pay that particular invoice, correct? I don't know if you are aware of that.
I'm not sure if I get that. Maybe.
Okay, let me rephrase the question. Are you aware of another example where the the invoice where legal department refused to pay because they felt that there was more of the communications input than the legal input in that particular case.
Yeah, I think I recall that.
Recall
Yes.
that, yes, okay, that's fine. But by and large, to your knowledge and to the knowledge of the legal department and the public protector, those services would have generally covered the legal aspects or the legal side of things. Hence, it was sent through you by Mr. Nyembe, correct?
Yes.
Yeah, thank you. Right. Now let's move to the issue of the cost orders, because that's another new area. I was going to start by recapping the work we did last time with you, but as I say, I've just been forced by circumstances to start at the end. So let's go to the question of wasted costs. You know, as an attorney, that there are costs, different types of legal costs that get awarded by a court of law, correct?
Correct.
And the kind of language that is used might be confusing to people who are not lawyers. So what we call the attorney and client costs are otherwise known as punitive costs. You are aware of that?
Yes.
And the court would issue such costs if it was showing disapproval of something that a particular litigant had done in a particular matter, correct?
Correct.
So, for example, when Mr. Godin and Mr. Pillay accused the public protector of being involved in state capture and all sorts of things, the court found, not only removed those remarks from the record, but also awarded attorney and client or punitive cost against them, correct?
Correct.
You were involved in that litigation?
Yes, correct.
Yes. And vice versa, sometimes the public protector, if the court disapproved of whatever it disapproved of, it would also award attorney and client costs against her, correct?
Correct.
Right. So that's one category of costs. Then there's the other costs which are called personal costs. And those are awarded in the case of a particular person personally, when the court feels that the institution should not be settled with those particular costs. You know about that category of costs as well, correct?
Correct.
Yes. And those costs are sometimes confused with punitive costs, but those costs could be ordinary costs, which are not punitive, but simply awarded against a particular individual litigant, correct?
Correct.
Okay, so that's what we call personal costs. And then there's the ordinary cost that gets awarded, which gets taxed. In other words, you only can recover from the other side. If you are the winner, you recover from the other side only those costs that have been taxed, correct?
Correct.
And the distinction between those costs and punitive costs is that in punitive costs, you can even recover costs, untaxed costs that have been expended by the attorney in respect of that matter, correct?
Correct.
So the second category, attorney and client costs, will tend to be higher than the ordinary costs, correct?
Correct.
Right. Now, there are other types of costs, but we don't need to go to that. Cost, the bonus proprius and so on. Yeah. There was an example of, let's talk about the CX matter. There was an email that was put up by Advocate Bauer regarding that matter. You remember where you expressed some views about the personal costs order that was awarded there and the punitive costs, correct? Where you disagreed with the court finding. You remember that?
I'm not sure if it was CX.
It was, I think it was Reserve Bank. Yeah, I think it was. Okay, but anyway, it doesn't matter. But where there was such an award and you had disagreed with the cost order. You remember that example that was given?
Yes.
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 And of course, various people had different views in South Africa. Some would have agreed, others would have disagreed. That was your view. Other people had different views. You are all entitled to your views, correct?
Correct.
Yes. Now, I just want to use that as I say as an example. In that particular case, because you were involved in the case, sometimes where people who are not involved in the case might not appreciate these things. It was your view that the personal cost order was unwarranted, correct?
Correct.
And is it correct that what you were instrumental, and I might be underestimating your role, but you were quite key in the compilation of the litigation strategy that was referred to in your statement, correct?
For which matter, Chair?
No, the litigation strategy in general.
Oh, okay. Yes.
I think it's referred to, sorry. At paragraph 37 of your statement, which will be on page 4020.
That's correct.
And that's why I was saying I might be underestimating. You say that when you became in charge of that legal unit, say there were no documented guidelines upon which a decision to litigate must be taken. And then you say, I crafted a litigation strategy 2020 to 2023, which was approved by the PP on 2 November 2020. So I'm saying, of course, it doesn't mean you did it on your own, but you were quite key in the crafting of that strategy, correct?
Correct.
And that strategy is the current strategy that covers even the period now as we speak, correct?
Correct.
Yes. And I want to link this to the question of the personal cost order and how you were aggrieved by what you saw as an unwarranted cost order against the public protector. One of the issues in your strategy was the fact that from that point on, some of the senior investigators and executive managers should be the ones who sign affidavits in respect of review matters, correct?
Correct.
And that in so doing, that would in a way protect the public protector from having to take the brunt or bear the brunt basically of an investigation where maybe her involvement was minimal, but simply because she was the one who had signed the affidavit, then the court would visit her with personal costs, correct? That was one of the motivations.
Amongst other things, yes.
Yes.
Correct.
Yes. And in fact, is it true that, well, that strategy of yours paid off? When I say paid off, I mean from the point of view of the public protector, at least in the GEMS matter, because it was not her who had done the affidavit, but the investigator involved, correct?
Yes, I think the GEMS was before the strategy was approved, if I'm not mistaken. I can.
Yes, but okay, but in the GEMS matter, the affidavit had been signed by someone other than the public
senior.
protector.
Yeah, that's correct.
Correct. And for that reason, I think the SCA specifically said that it could not mulct the public protector with a punitive cost order, among other things, correct?
Correct.
Yes, thank you. Right. Now, and to the extent that the GEMS matter was pursued, this was obviously then with the blessings of that particular person who signed the affidavit, correct?
Right.
As well as the legal department and everyone else, correct?
Correct.
It was not a sole decision of the public protector, correct?
Correct.
Thank you. Now, okay, I think then we've covered, these were the three areas that are new areas which I had wanted to deal with you today. I think we have covered. One was that your view that you have never experienced or felt that there was any wasteful or fruitless expenditure as far as the legal side was concerned, correct?
Correct.
The second one was that you felt on many occasions that the personal cost orders against the public protector were unwarranted, and you even devised a strategy to mitigate that fact, correct?
Correct.
Okay, and then the third area was the one we covered now about Mr. Ngobeni and Mr. Nyembe. So we've covered those. If we can then just come back to some of the ground that I think you and I had covered last time. I just want, it will curtail my cross-examination because I'll just give you the topics. If we agree, we agree, then, but if we don't, then we might get into some of the nitty-gritty. And this is about a dozen, 10 or 12 matters, such issues, but we'll go through them very quickly, depending on whether you combine some of them or not. Is it correct? Well, it has been confirmed by other witnesses, and I just want you to confirm if you are aware of this, because some of it might have happened in your time, some of it not in your time, but you can assist us because you are one of those people who served both under Advocate Madonsela and Advocate Mkhwebane at different times, correct?
Correct.
Right. Now, to your knowledge, it is true that there were successful reviews that were brought up against Advocate Madonsela, correct?
Correct.
And similarly, there were successful reviews that were brought up against Advocate Mkhwebane, correct?
Correct.
And there were unsuccessful reviews that were brought against Advocate Madonsela, similarly with Advocate Mkhwebane, correct?
Correct.
As far as the so-called scathing remarks are concerned, there were scathing remarks made by judges against reports compiled by Advocate Madonsela, and also scathing remarks made against reports made by Advocate Mkhwebane, correct?
Correct.
Then the third point is that which I want to check if we agree on, because these are issues that we will use when we argue at the end. Yeah, that again, there's been almost consensus on this, but just for the sake of progress, I want to confirm with you that the Nkandla case was a turning point insofar as it reduced, rather it introduced binding remedial action, in that it resulted in a predictable spike or avalanche of review applications, correct?
Correct.
And that spike in litigation would obviously be accompanied by predictable spike in the spend, in the litigation spend, correct?
Correct.
Right. And then fifthly, would you agree with me that I'm going back to the theme of context as well? Litigation is not something you can predict. Some have called it an unruly horse. In other words, you could have a matter that you think is complex and then it gets resolved in the first instance, or a matter that you thought was simple, but it goes all the way up to the Constitutional Court. It's not like you can look at a matter and say this one is going to cost R1 million, this one is going to cost R2 million upfront, correct?
Correct.
And an example of that is that, and this would have been in your experience as well, some of the appeals might have to go via Bloemfontein, as we say in the profession. In other words, they have to go to the SCA, but others go directly to Braamfontein, which is that they go directly to the Constitutional Court. That's not something you can know when you start litigation, correct?
Correct.
Right. And therefore, like any other department in any company or SOE or whatever, you obviously will have a legal budget, but it's really how it materializes is out of your control, correct?
Correct.
Even whether you are going to win a particular case and have to pay costs, or rather, and have to be paid costs, or lose a particular case and have to pay costs, is something you cannot predict upfront, correct?
Correct.
Right. Okay, then the sixth proposition that we're going to argue is that this public protector, when there was this escalation, even though it was predicted even by Advocate Madonsela, went out of her way to introduce austerity measures in order to control the legal spend, correct?
Correct.
And those austerity measures, we won't go through that because you testified about them the last time, but they included that almost blanket withdrawal of matters, except those that had set downs, correct?
Correct.
And that strategy, we can safely say, was implemented admirably, in that, as you say, those cases that were not withdrawn, which were exceptions to the rule, actually the public protector won those cases, except for one example, I think, out of 4, correct?
Correct.
And you identified those cases last time, so I will save time by not going back to that. And those austerity measures then obviously made a huge positive impact, not only on the legal budget, but on the financial performance of the entity as a whole, correct?
Correct.
Right. And I think you also covered this. This is my 8th point here. You agree that some of the cases that were then opposed or fought subsequent to that included crucial issues of the development of the jurisprudence around this office of the public protector, including section 6.9 and section 7.9 of the Public Protector Act, correct?
Correct.
In fact, I think, if I'm not mistaken, the GEMS matter and or rather in the Pillay matter, the judges remarked that it was the first time that they had to deal with this aspect of quote unquote prescription in terms of section 6.9, and they gave clarity to it, correct?
Correct.
And in the GEMS matter, the SCA also dealt with that section, correct?
Correct.
And then similarly, in the CR17 Busasa matter, the court gave clarity on the section 7.9 issue, which you and I canvassed on the last time you were here. I think it was the 26th of August, correct?
Correct.
And these developments of jurisprudence are generally beneficial to this area of work in our young democracy, correct?
Correct.
And you use them. The public protector will testify that you, well, not you personal, maybe you personally as well, but that there's a culture in the public protector involving her office, the legal office, and sometimes even the CEO's office of what we call in management terms a learning organization. In other words, when there's a judgment, you take that judgment, analyze it, and see what lessons can be taken in order to be applied in future reports. Can you confirm that?
Yes, I can confirm.
Right. And that obviously would be more so in cases where there are novel areas that have been developed in the public protector space, correct?
Correct.
One of the cases, I've already made mention of this when I was addressing the chair, but one of the cases that have been highlighted with regard to legal spend has been the case that has brought us here, the case of the application of section 194 of the Constitution, correct?
Correct.
And you are aware that this happened in your era when you were already in the legal department, the evolution of that particular case, correct?
Correct.
So maybe you can assist the committee and assist me, because I can't be a witness, even though I was involved in the matter. So you'll forgive me. I have to use you to bring out some of the issues there. Now, you would be aware that at the beginning of the evolution of that case, there were several attempts by the Democratic Alliance to bring the impeachment of the public protector, and it brought several motions in Parliament to do so, correct? Basically, almost since the day that the public protector was employed, correct?
Correct.
That went on for a number of years, and then until the public protector, having received legal advice from, among other people, Mr. Ngobeni and others, pointed out that the Parliament was making a big mistake because there were no rules which governed section 194, and there was a letter to that effect which was addressed to the chair of the portfolio committee and the speaker, correct?
Correct.
Thereafter, the Parliament then wisened up to that fact and started to devise the rules according to the advice of the public protector and her advisors, correct?
Correct.
Those rules were eventually passed on the 3rd of December 2019, after several false starts and debates within the committee about the content of those rules, correct?
Correct.
Then on the 6th, 3 days later, Honorable Member Mazzoni who was then the chief whip of the DA, did what they had been trying to do over the years and put the motion for impeachment, the first one, correct?
Correct.
And then I got involved, I think, around that stage. You then sought legal counsel at that stage, because then it was no longer an internal matter. It was quite a serious issue about the possible removal of the public protector, correct?
Correct.
And then you engaged the services of senior counsel and junior counsel, correct?
Correct.
And in January 2020, just before COVID broke out, the Speaker of Parliament announced that she had accepted the motion as quote unquote in order, and therefore she was going to action it. And she did that without informing the public protector, correct? She did it in a press release, correct?
Correct.
Okay, once the public protector read about this in the media, she then engaged the legal team as you have already confirmed, correct?
Correct.
And then I think a week later thereafter, a letter was written to the public, to the speaker, to say, please withdraw the motion because it has all these flaws, including the fact that it did not allow for legal representation. Its effect was supposed to be retrospective and all that. Remember that?
Yes.
And that was, as the public protector put in that letter, an effort to avoid any litigation and in the spirit of cooperative governance, Section 41 of the Constitution, correct?
Correct.
And the speaker refused to avoid the litigation and basically dared the public protector to do whatever steps, to take whatever steps she thought she wanted to take in order to protect her rights, correct?
Correct.
And therefore, the public protector then had no option but to go to court to assert those rights, correct?
Correct.
And then first, an application was therefore brought in the High Court, basically to declare some of the rules to be unconstitutional and also to interdict their implementation, correct?
Correct.
And yeah, the interdict application itself was unsuccessful, but the challenge to the rules was successful to a significant extent, particularly in relation to the involvement of a judge in this process, and as well as the issue of legal representation, correct?
Correct.
And that success of the public protector was achieved at the High Court in the Western Cape, and that would have necessitated change to the rules, correct?
Correct.
At that point, the National Assembly and the Democratic Alliance decided not to accept that success of the public protector, and they appealed directly to the Constitutional Court. You remember I made that example. Sometimes you appeal to the SCA, sometimes to the Constitutional Court. And I think in this case, they did a double-barreled appeal to the Constitutional Court, but conditionally to the SCA. Remember that?
Yes.
And the Constitutional Court decided to hear the matter, and the public protector again was successful in respect of the assertion of the right to legal representation, but unsuccessful in respect of the second issue, which was the separation of powers, correct?
Correct.
Right. Now, that litigation then, to cut a long story short, came the second round where this committee decided to proceed with the matter, despite of the fact that it was still pending before the Constitutional Court. Correct?
Correct.
Right, and that then brought us to the current litigation, which everyone knows about. Again, there was an interdict application and an application to declare both the suspension proceedings and the proceedings in this committee to be unconstitutional. Correct?
Correct.
And currently, we, as they say in the industry, the jury is still out as to whether that challenge to the suspension as well as the continuation of this process that we're sitting in now is constitutional or not, in the sense that we're awaiting a judgment that has been reserved in the Western Cape High Court, correct?
Correct.
And that history, starting from the refusal of the speaker to accede to the plea of the public protector to handle this matter amicably, is what has led us to the figure of litigation that was given to you this morning, correct?
Correct.
And one can only imagine that that figure is probably twofold or threefold if you consider the fact that the other side had separate teams represented by senior counsel. There was a team of the National Assembly, correct, with senior counsel, correct?
Correct.
And at some point, and then later on, there was a team of the chairperson of this committee or this committee, and that council was the same council, or not I don't mean one council. It was either one or two or three persons, depending at what stage. But those people represented the National Assembly and this committee, correct?
Correct.
And then there would be a separate team also led by senior counsel of the Democratic Alliance, correct?
Correct.
Then there was a separate team also led by senior counsel of the President of the Republic of South Africa, correct?
Correct.
When he was participating, in fairness to him, he did not participate in the first round of those interdicts. He simply put in an explanatory affidavit. Do you remember that?
Yes.
Thank you. And we don't know how much public money was spent by those teams as we sit here, correct?
I don't know.
Yeah, even though eventually the public protector's position was vindicated, at least in the first part. We don't know what will happen with the second one about the suspension and the current process. Correct?
Yes.
Thank you. So that I was using that example to show that, when you put context to matters, yeah, it's easy to just mention millions or billions or zillions, but without putting any context to the matter. Thank you very much. All right. Now, the next issue that that you and I covered last time, and again, you may or may not be able to assist directly. I think you made it clear that you were fortunate you never received an Audi letter, but I just want to talk about that a little bit more. We spoke about it last time. Here, it looks like, Mr. Sithole, maybe you can assist us. I don't know if I put it like this to you last time. There seem to be two schools of thought about this from the witnesses that have been called here. Some witnesses view the issuance of Audi letters as something bad, and others view it as something good. which is linked to the new performance culture that the public protector was trying to instill. And I appreciate that you never received one yourself, but from your experience, did you, and having been an investigator at some stage, would you agree with me that the issuance of Audi letters was directly linked or an integral part of the new performance culture that the public protector was trying to inculcate in the organization?
I'm not sure if I can comment on that.
Yes, okay. Let's do it step by step. Well, being a person who was in the privileged position of having been there before Advocate Mkhwebane and having been there after she was employed in that position, would you agree that she did her best to improve the performance culture of the organization?
Yes, correct.
Yes, and if you could compare the two eras, particularly in respect of the output, the things that we know, would you agree that the performance culture improved significantly under her watch?
I can't say with certainty because during the former people's time, I was a trainee investigator for a period of 2 years.
Okay,
Yeah.
fine. Okay, no, that's fine. So let's even not do that. Let's compare then the times that you were there. Let's say when you came back 2017, and let's say 2 or 3 years later, 2020 or 2021, would you say there was a progressive improvement in the performance culture?
Yes.
Good. Now, and you would have known about or attended, I don't know which of the meetings you'd have attended, but the meetings that, or at least you know, that some of the meetings that where performance was driven included think tank, dashboard, full bench, there were all those fancy names, but those were meetings that were meant for pushing performance, correct?
Yes, I think it was task team and dashboard more specifically.
More specifically, yes.
Yeah.
Right. And there's evidence that's already been led that at some point think tank was abolished, and there was a much tighter task team that was located in the office of the public protector, but it also did quality assurance, correct?
Correct.
And you can confirm this is common cause. That one of the issues that the public protector will also testify about is that think tank, one of the weaknesses of think tank, although it was a good quality assurance mechanism, is the fact that it's set only quarterly, 4 times a year, correct?
Yes, that's correct.
And then it involved a lot of costs, everyone having to fly from all over the country, staying in Pretoria in hotels for days. And so it became a bit cumbersome, particularly in the days of austerity, correct?
Correct.
Right. Now, the point I was really coming to is the fact that it was to check with you whether, and you may not be able to comment on this because you are not an HR specialist. I think Mr. Kielela did comment on it. Yeah. But to the extent that you know about management in general, you are aware that that environment is driven by deadlines. In other words, the output for the public has something to do with not just whether a report is given out, but how fast that is done, correct?
Correct.
And therefore, the management task that you are all seized with, from the public protector to the person who sweeps the floor, is to manage this tension or balance between quality, which we have just spoken about, and quantity, in other words, the output and the rate of output, correct?
Correct.
And it's not an easy balance because now and again, you don't want to chase quality to the extent that you sit with a particular report for 10 years, but you also don't want to chase quantity to the extent that you issue it out in 2 weeks and it's a half-baked report. So it's always a balance, correct?
Correct.
Right. And it's a balance that you would say that the public protector was, those of us who are sitting outside, it's easy to, to criticize, but it's a balance that you and your team and the public protector always sought to strike in terms of ensuring that there is quality, but at the same time, there's qualitative output, correct?
Correct.
Right. And that has resulted in unprecedented output as well in terms of the numbers that you have achieved as an institution, correct?
Correct.
It has also resulted in unprecedented financial performance in the sense that you have achieved 2 successive clean audits in the process, correct?
Correct.
So you were not just chasing quality or even quantity, but you were also chasing good governance, correct?
Correct.
And well, we don't know whether you'll get a 3rd clean audit now that the public protector is not there for the year. I mean, a 4th one for the year 20. You know that she was suspended around about June of this year, correct?
Yes.
And that was after the year end of the 2022-2023 financial year, correct?
Yeah, 21-22.
21-22, correct, yes, which was reported recently, correct?
Correct.
And I suppose then that's why I was saying the 4th. Congratulations are in order to you and the team, because the under public protector Kwebane, you have now achieved a 3rd clean audit, correct?
Thank you, Council.
Are you aware of that?
Yes, I was made aware. If I'm not mistaken.
No, it's my pleasure. So why did you not announce it yourself? Why did you wait for me to, to give you all the accolades? Yeah. When you have a 3rd clean audit, Mr. Sithole, it's not time to be modest. I seriously mean congratulations to you and Advocate Mkhwebane for your 3rd straight clean audit. Okay. And as I was saying, the jury is still out whether you'll get a 4th one because she's not there now, but she'll be back, don't worry.
Yeah, I think it's the entire PPSA staff that must take the credit, not just me. Yeah.
Not just you, yeah, no, not just you. Well, there you go, becoming modest again, Mr. But you can take the credit for them. You'll report back when you get back to the office. If you find it too hard, the public protector will do it herself when she comes back. Thank you, Mr. Sithole. Okay, now the issue of okay, no, I wanted to just without rubbing the point before the chair can stop me, that you can therefore agree that with the example that we gave, where the National Assembly and this committee lost cases against the public protector, that the public protector does not have the monopoly on losing cases. Even this committee lost cases against her, correct?
Correct.
Yes. And the last point that I wanted to deal with, and again, I'm just taking advantage of you as a lawyer, is there's also findings of irrationality which have been made from time and again against whether it was Advocate Madonsela or Advocate Mkhwebane. You've already confirmed that, correct?
Yes.
But I wanted, because sometimes, these words, what they mean in legal terms and what they mean in normal English can be confusing to non-lawyers. I made an example the other day about relevance and things like that. Yeah. But can you assist the committee by explaining that rationality in legal terms simply means that a particular act or decision or conduct does not conform with the rule of law, and we lawyers call that irrational, correct?
That's correct.
So, for example, the decision of the National Assembly not to allow Advocate Mkhwebane legal representation was found to be irrational. That doesn't mean that Parliament was crazy. It just means that they did not conform with the rule of law, correct?
Correct.
Yes. Okay. Sorry, Chair, I'm just looking at a note that I've just received. Okay, now the last point. Thank you, Mr. Sithole. Those are the highlight issues that I wanted us to deal with as far as the whole legal department issues concerned, plus the three new ones that we dealt with this morning. There's just one more issue that I wanted to revisit. Again, I don't want to waste your time because we dealt with it the last time. But just to be sure that in your experience, you were aware of the fact that the public protector was one of the people who was of the view that the Gupta leaks should be used in the Friday report, correct?
Correct.
But that view, and I'm sure there were other people, I don't want to credit her alone with that, but that view of hers was defeated by the other view that it was not necessary, among other things, because the Gupta leaks were to be dealt with in the Zondo Commission, correct?
Amongst other things, yes.
Yes, thank you. And then also you confirmed the last time that in your experience, someone who was there at the coalface of this investigation, there was no so-called alleged narrowing of the scope of the investigation, correct?
Yes.
Right. Now, I don't think I've finished asking you about the issue of the Audi letters. I wanted to ask you, in your own experience or experience of others, did you see these management tools, including Audi letters, which were linked to the performance, as something negative, or did you see them as something positive, which would have contributed, for example, to the 3 clean audits that the organization has achieved?
I'm very much wary of commenting on the issue of Audi.
Yeah. No, okay, then I'll lead you like this. Yeah. Have you ever had any personal or indirect experience of somebody having been given, okay, let's start it like this. As a lawyer, you know that Audi alteram partem means giving somebody a chance to be heard, correct?
Correct.
And that's a good thing, to give someone a chance to be heard, inherently. It's one of the rules of natural justice, correct?
Correct.
Yeah. Now, it would seem, and I don't want to overstate this, it would seem that, there's a a saying in English that says too much of a good thing can be bad. Yeah. So even though you and I can agree that Audi in itself is a good thing, it would seem that there are people who experienced it negatively. I'm just wanting to check, you are not one of those persons, or you are not, that never happened in your own experience, either to you or someone that you were relating to, correct?
Correct.
Thank you. All right. Okay, that's fine. Then I'll put you in the other school of thought, whether you like it or not. But it's fine. We'll develop this later when we argue. But in fairness, you must be aware that there are these two schools of thought about that particular method of management called Audi letters. Correct?
Correct.
If you nod, it's on record. I'm saying when you
Sorry?
nod, I'm saying when you nod, it doesn't record. So you have to say something.
Okay, yes, no, that's correct.
Is that correct?
Now, I agree that you say you develop it in argument.
No, that's not the question I'm asking you. I'm saying you would have been aware, even with, not from personal experience, that there are what I've called the two schools of thought about it, correct?
Yes, that's correct.
Thank you.
Advocate Mpofu.
Thank you, Chair. Tea time.
No. I want you to wrap up.
No, Chair.
Yeah.
Okay, Chair. You know, okay, let's make a deal, Chair.
Goes
Can we
towards
take-
the. Okay.
No, I'm doing that, Chair. Okay, let's take the tea break, because that might make me not to ask any further questions. But I just want.
We're done with the tea break. It's all up to you now. We're done with the tea break.
When
the
was
next
that?
thing is lunch.
When was the tea break? I must have missed it. I thought you were just chairperson. Okay, that's fine. I thought you were doing that because you couldn't hear me, but that's fine. I didn't have my tea, so I must have missed the tea break. No, fine, Chair. I'll wrap up then. Mr. Sithole, sorry, Chair. There's a specific issue that you were asked about the last time, and it goes back to the issue of the services of Mr. Ngobeni. I don't know what was being suggested, but I just don't want to leave anything to chance. You would be aware that I think we've already covered the fact that Mr. Ngobeni was engaged at the recommendation of Mr. Nyembe, correct?
Correct.
And we are also aware that Mr. Nyembe's mandate in the Public Protector's Office as a special advisor would be wider than just legal matters. It covered all sorts of things, communication, the economic landscape, the political landscape, you know, the environment, in short, in which the office operated, correct?
Yes, that was when he was special advisor and also when he was chief of staff. And I think there's evidence that was projected where he says he also provides a strategic advice on litigation matters.
Yes, and I'm saying that well, we're not sure where that evidence came from, but to the extent that just in your own experience, you'd at least accept that in both capacities, his scope was wide and covered what I have described as the environment, sometimes hostile environment in which the public protector operates necessarily, correct?
Correct.
And that is that's the hostile environment, for example, that I'm referring to. It might vary in degrees. It's not confined to Advocate Mkhobane. Any public protector operates in that hostile or relatively difficult political, economic, and social environment just by the nature of the office, correct?
Correct.
Right. Now, so I'm saying then that the evidence will be that in that context, Mr. Nyembe then was of the view that for when there was a particular hostility that was perceived, whether it was real or perceived, it doesn't matter, that the services of someone who's not for lack of a better word, a straight-jacketed lawyer who's not just going to deal with the legal aspects, but also with the broader aspects. Hence, he recommended Mr. Ngobeni. You may not be aware of that, but that is what will be put. You can't dispute that, correct?
Correct.
Right. And to the extent that the attorneys, in fact, at some stage, and I don't know whether you were one of these people, but at some stage, Mr. Ngobeni was even referred to as a senior counsel until it was discovered that he was an ordinary advocate, not a senior counsel. Sorry to say ordinary, but okay, say even senior counsel are ordinary advocates, but that he was not a senior counsel, correct?
I don't know.
You're not one of those people. Okay, that's fine. That will bring that evidence here. But in any event, using one of the methods, 7 methods that we spoke about, Mr. Ngobeni's services were then acquired through the services of the whatever attorneys were involved in that particular matter. Correct?
Correct.
And you yourselves would not have been privy to, for example, if Mr. Ngobeni, except for the situation where he was briefed together with a practicing advocate, you would not have been privy to what other services he would have acquired, either in terms of legal research or the communications research or whatever the brief might have been, correct?
Yeah, my involvement would have been to the extent that it relates to obtaining an opinion.
Yes. Yes, I agreed. Yeah, and what
I'm saying in
is
respect of the evidence that we dealt with last week with Advocate Power.
With Advocate Power, no, fine, that's true, and that would apply even if that counsel was me or someone else. You'd ask for an opinion. If it involved any other expertise that I might acquire, that would be my business, correct?
Correct.
Yes. All right. And then there was a specific question which was put to you, which I want to clarify because we have evidence which might not coincide with what you were saying, or maybe it's not what you were saying. I just wanted to clarify it. In particular, with there was the invoice that had gone to Sianeho attorneys to do with an opinion done by Mr. Ngobeni, which reached you on the letterheads of Mr. Sianeho. Remember that example?
Yes.
Yes. And in terms of that, and I don't know, maybe Advocate Bauer can assist me, but we don't have to put it up. We're not positively averse to this thing of putting people's accounts up there. So I'll try to ask you this question without doing so. Are you aware of that in that particular invoice, one of the items for which the Sianeho attorneys had charged was on redrafting the opinion? If you may remember that from memory, otherwise we might be forced to put it up. You remember that?
Yes.
Yes. In other words, and also that also happens that an opinion can come from counsel, maybe not in the required format, and then the attorney adapts it, and because the attorney is a lawyer as well, and even put some of the legal inputs, and then it would then come from the attorney. But obviously, transparently, you would know that it originated from the advocate, correct?
Correct.
Yes, that's in your experience as an attorney, or also just as from where you sit, there's nothing untoward with that practice, correct?
Yeah, in terms of formatting, I don't
Yes.
think there's a specific format that an opinion comes in. I think what was put to me by Advocate Bauer was why it was in that format, and I responded that I'm not sure why Advocate Ngobeni's word will not appear there. I think I also indicated to Advocate Bauer, she'll correct me if I'm wrong. It was either during my in-chief, during the leading of evidence, or when we consulted.
Yeah, it would have been in chief. I didn't ask you about it. It would have been in chief.
To say Advocate Ngobeni does not have a practice per se. So ordinarily, when we get opinions, they'll be in the letterhead of the bar or the chamber that the counsel is in. So I was just giving an example as to maybe that's why his opinions will be either in the letterhead of Mr. Sianeho or will not be in a letterhead at all.
Yes, okay, fair enough, yes. There are, and okay, I don't want to go down that road, but you know that in South Africa, there are advocates like me who belong to a particular bar, but there are also other people who are independent advocates, correct?
Correct.
And attorneys sometimes use us, the conventional advocates, but sometimes they use the other advocates, and particularly before the act came into being. That was the practice, correct?
Correct.
And I don't know what the situation is now under the act, but I think that even those independent advocates are now required to be registered with the LPC. But before that, that was not a requirement, correct?
Correct.
Right. Okay. Yes, let me just, Chair, I'm trying to keep to my promise. Just want to see if there's any other specific. Chair, if you just bear with me 1 second. Yes.
After so many days, after so many days. So that is why to attack this pointed deadline, because we are
Okay, thank you, Chairperson. Sorry, thank you for the indulgence. The issue that was being raised by my colleague was the issue of deadlines. I think in fairness, Mr. Sithole, we covered that. You did acknowledge that to achieve some of these unprecedented achievements that your office has achieved, and as you correctly say, credit to everyone, the entire team. The performance management, among other things, was driven by this issue of deadlines, of imposing deadlines, correct?
Right.
And it was that discussion that you and I had about trying to marry quantity versus quality. The quality, both the quality and the quantity, has to be deadline driven. In other words, if you are sitting at think tank or dashboard or whatever it is, it can't just be a question of saying you must do this next week. You must also do it properly, correct?
Correct.
Because otherwise anyone would comply with all deadlines if it was just if there was no quality element to it, because you'd simply just submit whatever shoddy work you have done, correct?
Correct.
Yes, and that offices like this, which service the public in particular, I mean, I know in my experience, because of the space that I'm in the judiciary, if a judge doesn't issue a judgment within 3 months, then the judge president starts to put pressure on them and lean on them. And if they don't do it after 6 months, then it's regarded as misconduct. And I suppose they get an Audi letter or whatever the equivalent is. But you would know as a person who's involved in the courts that there are timelines after beyond which you can complain as a litigant if the judgment is not out, correct?
Correct.
Yes. And also, and those rules are indiscriminate in the sense that it might be that a judge has to do a judgment within 3 months in a simple matter that was where the file was 10 pages, or it might be a complex case where there are 10,000 pages, but they still have to deliver within the timelines. Otherwise, it's misconduct, correct?
Correct.
Yes. And quite frankly, and I'm now asking you as a South African, we would never be able to achieve service delivery if we don't impose deadlines, even if those deadlines might be uncomfortable, correct?
Correct.
Thank you, Mr. Sithole. And maybe I should ask you this thing that the chairperson has not stopped me yet. I'll ask you one more question as a South African. Would you agree that we should never reach a stage in South Africa where we punish people for performance or over-performance and leave alone those who give us load shedding, for example?
I'm not sure if I get that.
No, it's fine, Mr. Sithole. Thank you very much, Chairperson. No further questions.
Thank you, Advocate Mpofu, before you are load shedded. And Mr. Muntu, thank you for, we're now going to quickly proceed to members and recognize members who want to make a contribution by way of questions to Mr. Muntu Sithole, who's been with us since when we paused. I will start with the Honorable Deborah Peters, followed by Honorable Mkweba, or Gondwe, Heron, Mailam, Mananiso, Honorable Ngosi, Ngola. In that order, time now is 12:05. Honorable Deborah Peters.
Thank you very much, Chair, for the opportunity. Good day, Mr. Sithole.
Good day.
Thank you. Mr. Sithole, with respect to the Friday Dairy litigation, the matter brought by the DA and CASAC, you'd remember, the Office of the Public Protector appointed 2 separate legal counsels for the same matter. Were you consulted about this by the PP?
I'm not sure if I get the question, if the honorable member can repeat.
My question is with regard to the Freddy Dairy matter, where 2 councils were appointed. And I wanted to know whether you were consulted with regard to this matter.
We were consulted by the council.
You were consulted by the council, but not the PP.
If Honorable Peters is referring to us employing 2 sets of counsel, the evidence I gave was that we were requested by Advocate Ngalwana, who was a single silk in the matter, to get the services of an additional senior counsel to assist in the filing of heads and arguing of the matter in respect of KSEC. So if Honorable Peters is referring to that, yes, we were consulted by Advocate Ngalwana, who was with the junior at the time.
Thank you, Mr. Sithole. Mr. Sithole, my second question is with regard to there being a panel of attorneys in the Office of the Public Protector. I want to know from you, why does it seem like Sianeho is getting the lion's share of the cases?
Thank you, Chair. Yes, it may seem that Sianeho gets the lion's share of cases, but the truth of the matter is that they have matters which have received a huge public coverage, and that has created an impression that they are the only firm that has actually done matters for our office. But you will see even in the schedule that the evidence leader has shared with the committee, and that which we may share next week once we confirm the figures. Even the schedules of litigation, you will see that actually there's 1 or 2 other firms that has more work or received more work from us than Sianeho. The only difference is that Sianeho has received matters that have received a huge public coverage. And firstly, secondly is that the matters that were dealt with by Sianeho are matters that are interlinked. So it matters that relates to the same questions of law, or they are linked in terms of a web of facts or litigation. For example, the 2 Godan matters raises the same questions of law, and then the speaker matter arises from the same charges that relate to Mr. Godan matters, KSEC matters, and I think 1 other matter which Mr. Sianeho has been involved. And that Honorable Peters will explain why Mr. Sianeho is actually representing the PP now, because the firm has been involved in all these matters that are now sitting before this committee for determination. So it's not a matter of a random selection that we want this one. Otherwise, it would have been more expensive to get 5 sets of lawyers to deal with matters that are interrelated. It would have meant that we needed to appoint, for example, for the purposes of this exercise, more than 1 attorney who must now bring these files that relate to this matter, bring these files that relate to this matter. Whereas we have Sianeho, who already has records of Praveen on 2 matters, already has records on DA Kasak. So it's just the issue of cost effectiveness and convenience, so to speak. Thank you, Chair.
Chairperson, with regard to the Kasak matter, how does the Office of the Public Protector arrive at the point where a law firm is removed for a preferred one, and in this instance being Sianego.
Thank you, Honorable Peters. I can't remember exactly why we removed the previous firm, but we engaged Sianego only for the purposes of appeal. So the litigation in the High Court was done by TGR, and then we engaged the services of Sianego attorneys, I think from the appeal stage, if my memory serves me well.
Chair, thank you very much. Have this scenario, Mr. Sithole, played itself out in any other case? Thank you.
Is Honorable Peters referring to the one of removing an attorney?
Yes, Chair.
Yes, it has. As you will recall, Advocate Bauer indicated earlier today that we had Chadl Thompson noting the judgment in the Constitutional Court. We had Fasken before Chadl, and there was a dispute between the office and Fasken, but the dispute came after the hearing, so we changed attorneys there. There was another instance in the matter of PP versus Breitenbach, where we changed attorneys because they were not delivering the service that was required. So when I joined legal services, I remember my senior then preparing a memo that we must terminate a certain firm for another. Thank you.
Thank you, Chair.
Thank you, Honorable Peters. Honorable Mgwela.
Thank you very much, Chair, and good day all. Mr. Sithole, in your affidavit in paragraph 18, you have said that problems do arise. The investigation team who cannot find documents on which they relied for a report, although it was available to them at the time they have drafted the report. So, Mr. Sithole, how so? Do you want to tell this committee that at the PP's office there's incompetence and then your systems are questionable in terms of keeping records from investigations?
Thank you, Chair. I wouldn't say there's incompetence. I think it's just the issue of record management, and I'm happy to take the pinch for the investigators in the sense that we don't have a proper filing system at PPSA. So if you are an investigator, for example, you investigated a matter in 2016, you concluded it, most likely that investigator is sitting with the box of those files, despite the fact that the matter was concluded, and there's new matters that come in. So it presents problems sometimes to actually even trace some of the documents that you had in your position. You have to look at each and every box. So that's the problem that the investigators communicate to me. But even myself, having been an investigator previously, I can confirm that the issue of record management was a problem and not necessarily the issue of incompetence.
Thank you very much. And in paragraph 21, the report of the public protector on the Friede Dairy matter indicated that the PP did not investigate some matters due to capacity and financial constraints experienced by the office without describing the capacity or financial restraints were. Do you think the reasons advanced by the PP for not investigating the matters thoroughly were justifiable? If yes, why?
Thank you. My view on that was, or is that the PP was not saying I'm not going to investigate these matters, but she was saying I'm deferring the investigation if my recollection serves me well. And I think that's what was also filed in the papers in court, where our argument was that the PP can actually opt out or defer some of the investigation to the later stage. So the recordal of financial constraints, I don't think it necessarily meant the PP is refusing to investigate at that time, but I think it meant those issues can be investigated later on. Thank you, Chair.
The last question, the evidence, Mr. Sithole, before this committee is that in relation to CR matter was prepared by Mr. Paul Ngobeni and submitted under the name of Sithole Attorneys. And then Sithole paid Mr. Sianeho, paid Mr. Ngobeni from his work to receive instructions from the PP to instruct Mr. Ngobeni to do any work, and if so, in relation to what precisely? Thank you, Chair.
Thank you, Chair. Yes, I think I previously stated when I was here that the instruction firstly came from Mr. Nyembe, who would have in most likely would consulted with the PP. And in respect, to be specific to the question, in respect of CR17, it was for the purposes of an opinion which was projected the last time by the evidence leader.
Thank you. You're done, Ms. Mkweba. Honorable Mkweba.
Thank you very much, Chair.
Okay, Mafako. I now recognize Honorable Konde.
Thank you very much, Chairperson. Dumela, Mr. Sithole.
Dumela.
Please, can you confirm what Mr. Ngobeni's qualifications are and what his professional background is?
I can't confirm that now, but I know that he has a legal qualification. He practiced as an advocate in the United States until he came back to SA. So I can't confirm out of my head what his qualifications are.
Okay, I know you've already confirmed this in your evidence in chief. So you confirmed that, to your knowledge, he is not a senior counsel, and neither is he registered with any bar in the country.
Correct.
And neither is he an attorney.
Correct.
Thank you. So can you please confirm in what capacity Mr. Ngobeni was engaged by the Office of the Public Protector? What did the agreement engaging him to provide service to the Office of the Public Protector stipulate? Did it stipulate that he was being engaged as counsel or a consultant by the Office of the Public Protector? And what sort of service did the agreement canvass when he was appointed? I'm asking this because I want to get clarity on the type of services that he was rendering to the Office of the Public Protector. Because in your evidence in chief, at the beginning, you stated that he was providing legal opinion. So I want to understand the basis of his engagement.
So what is your question again before you respond? You've said so much. Even the check gets lost about what your question is.
I wanted him to confirm in what capacity Mr. Ngobeni was engaged by the Office of the Public Protector, number one, and did the agreement that confirmed his appointment, I assume he was a service provider, stipulate whether he was being engaged as counsel or as a consultant by the Office of the Public Protector. And I want details around the type of services that he was rendering in this regard.
Thank you, Chair and Honorable Gondwe, capacity, he was briefed as an advocate, not as senior counsel. So he was briefed as counsel. Nature of the service, he was briefed to provide opinions in various matters. In terms of the agreement, there is no agreement that is put in place between the office and the counsel or the advocate. We enter into an agreement with the attorney. So in our letter, which we projected today, you see that in the letter, when we appoint an attorney to get counsel's advice, we say these are the issues that the counsel must provide an opinion on. So that is the nature of the engagement of a counsel.
Chair, Mr. Sithole would look the other way when he's responding, so I didn't catch some of his responses. Can he just repeat what he said?
Okay, sorry. Apologies, Chair and Honorable Gondwe.
Just repeat what you said. Don't respond to you looking the other way. It's we can look the other way and respond.
Yes,
So
please
just
speak into your
respond.
microphone or.
Okay, Chair. Chair, the reason for that is that I write the questions down, so I look at them when I respond. But I will respond then without looking. The first question was capacity. He was engaged in his capacity as an advocate. The nature of the service, he was engaged to render an opinion on various matters. Agreement, there was an aspect of the agreement. We don't conclude an agreement with the counsel. We conclude an agreement with the attorney, which details the nature of the questions of law, which we require the counsel to render an advice on.
So can you confirm which attorneys used them in this regard in terms of providing those legal opinions?
It's Sianeho attorneys.
So I just want to get the story correct. So Mr. Nyembe recommended to who that Mr. Ngobeni should be used? Did he make that recommendation to Sianeho attorneys, or did he make it to the Office of the Public Protector?
He make it to Sianeho attorneys. So even if he communicates it to us, we then pass it on to the attorney who is appointed to assist.
Okay, so I take it then that Sianeho attorneys briefed Mr. Ngobeni, knowing full well that he was not a senior counsel, and neither was he registered with any bar in the country, and neither was he an attorney.
That's correct.
So Sianeho attorneys briefed Mr. Ngobeni of their own volition. So they were not influenced by Mr. Nyembe as political or special advisor at the time.
No, that's not correct. The choice of counsel is from our office in one of the scenarios. If we look at the 7 scenarios that Advocate Mpofu stated. So Mr. Sianeho will not have on his own briefed Advocate Ngobeni. So that instruction would have come from our office.
Come again, because earlier on you indicated that he was briefed on the advice of Sianeho attorneys.
No.
No, okay, so please just
okay. Let me then try to simplify it. So what happens is, let's say we want to obtain an opinion from a counsel in respect of a specific area of law or whatever. So what we do, because we have a panel of attorneys, we select from the panel of attorney who we want to appoint, and then we instruct that attorney to appoint the counsel who will render an opinion on the questions of law which we seek clarity on. And then the attorney will, on those instructions, appoint that counsel to provide an opinion.
So
I'm not sure if
Mr.
that.
Mr. Nyembe played no role in Mr. Ngobeni being briefed by Sianoko attorneys. Is that what you're saying? And the Office
he
of the
played
Public
a-
Protector didn't play a role in that scenario?
No, he played a role. What we said is that he is the one who recommended Advocate Ngobeni to render these services. So on those instructions, we communicate the instructions to the attorney to say, please brief so-and-so to render an opinion on this. It's the same thing with litigation. We'll give an attorney an instruction to say, brief so-and-so, or the attorney in some instances will say, we prefer to brief so-and-so to do the work for you. So it's always the instruction of the client to get the choice of counsel.
So the Office of the Public Protector requested that Mr. Ngobeni be briefed by Sianoko attorneys, knowing full well
Correct.
that the gentleman in question is not a senior counsel and he's not registered with any bar in the country, and neither is he an attorney. Is that your evidence?
Correct. Yes.
Thank you. So I want to be honest with you. I find it extraordinary that Mr. Ngobeni was remunerated by the Office of the Public Protector to write online articles in defense of Advocate Mukhwebane under the pretense or the guise that he was in fact providing legal opinions. I mean, these online articles were passed off as legal opinions in the various, fee notes and invoices. Were you aware of the fact that, he was in fact writing these online articles in defense of Advocate Mukhwebane and they were being passed off as legal opinions?
No, I don't think that is correct. What I said in my evidence, which I repeat now, he was sourced to render a legal opinion. Those opinions have been provided to the evidence leaders, and I think they've been provided to the committee. In addition, he then wrote articles which were published, I believe, in 1 or 2 media outlets. So the opinions were rendered. If there was a question of the guise, it would have been in an instance where there is no opinion at all. Then I would have said, no, this is a guise because he never rendered an opinion on this. So there was an opinion on top of.
But we were shown fee notes or invoices that allude to legal opinions, but in fact it was a link to an online article. How do you explain that?
No, I don't think that's correct. The fee note you're referring to, I think the first item relates to an opinion, drafting of an opinion. And there's few other items that follows. And I think the last 2 items then relate to the articles. So the opinion is the first item.
So
that will be your last point.
You are, Chair, just.
Yes, it will be your last point. You must check your time.
All right, just 2 more quickly. So Mr. Sithole, you are denying that he was in fact remunerated by the Office of the Public Protector for those online articles?
No, I was responding to the question of the guise, that he was guising, writing opinions in the space of articles. I was saying.
So he was paid for those online articles, is that what you're saying?
He was paid because those invoices were paid that were projected here. So he was paid for the opinion and those items that are listed in that invoice, which included writing and publishing an article. So that's in one invoice. So I'm not denying that he was paid, otherwise I'll be lying.
Oh, okay, and you're not denying that you signed off on
Yes.
the GRN1 form,
GRN,
confirming that the
yes.
services is one order, including the online articles. But is this not in
That's
contravention?
exactly
of
your last question,
S-
Honorable Gondwe.
Yes, yes, yes.
Thank
Is
you.
this not in contravention of SCM regulations?
I'm not sure in what way, Honorable Gondwe.
Because there's no mention, I didn't see a mention in those fee notes of any online articles. I saw mentions of, I saw references to legal opinions. So I want to understand, was he paid for the legal opinions together with the online articles? I mean, I'm really baffled.
Yes, I've already confirmed that, Honorable
All right.
Gondwe,
Thank you.
Thank you very
that he
much.
was paid for both.
Thank you, Mr. Sithole. Honorable Heron.
Thank you, Chair, and thank you, Mr. Sithole. Mr. Sithole, I want to start with your affidavit at paragraph 43, which is on page 4022, where you refer to the EFF versus Speaker of the National Assembly decision. And then you say, when Advocate Inquiry assumed office, there were approximately 25 review applications, with it being clear that the number would increase in future. Were you, that portion where you say it would be clear that the number would increase in future, was that in relation to the findings of the EFF versus Speaker? I mean, is that what you're saying, that you're expressing a view that the EFF versus Speaker of National Assembly case would give rise to an increase in the future? Where does that come from?
Thank you, Chair. Thank you, Chair, and good day, Honorable Heron. The context for that, Chair, is that the EFF versus Speaker judgment essentially was to the effect that the remedial action of the public protector is binding, meaning once the public protector issues a report and she takes a remedial action, the person who must implement or who is being implicated has no choice but to implement the implementation of the remedial action. So the rise or the context of the rise of litigation meant each and every report was most likely to be challenged, because no one will want to sit with the report to which the findings doesn't agree with without implementing the remedial action. So the spike is in that almost everyone against whom a finding has been made and a remedial action is meted will then go to court to challenge that. Because pre-Nkandla, and maybe to add extra context on the Nkandla matter, the submissions by the former president in this matter was that the remedial action of the public protector is a mere recommendation. It's not binding. So previously, that's how the remedial actions of the public protector were treated. They were treated as a mere recommendation with no significant legal consequences. So the EFF judgment effectively said, no, the remedial actions of the public protector are as good as a judgment. If you are not happy with it, you must take it on review or you must implement. So that's the context of what gave rise to a litigation after the EFF judgment. I'm not sure if Honorable Heron is covered by that response.
Yes, thank you. Thank you very much. So did that that line in your affidavit and that concern or observation that the judgment would change the landscape for the public protector, was that factored into the litigation strategy and protocol that you refer to in your affidavit and gave evidence about?
Yes. Actually, if you look at that strategy, it actually codes the same judgment. So it was factored in.
And when we saw the table of legal costs over the last 6 or 7 years, would the legal costs then have included securing or defending the report that gave rise to that judgment?
Can you please repeat?
Earlier
Chair?
today, we saw a table of legal costs over the last, I think it started from the 2015-2016 financial year. And it was just an amount that was spent in each financial year with a total of 146 million rand. Included in there, would that have included the securing of the EFF judgment, which gave rise to this binding, that the remedial action is binding?
I think so, Honorable Heron. I must just check with Advocate Bauer if there's fees that we incurred up to the stage of the current PP, but I think it does, yeah.
I've got just two more questions. I just want to go back to also to the appointment of Mr. or Advocate Ngobani. In the process of selecting counsel or experts or to give advice to the public protector, I mean, is there a process where legal services or the public protector would consider the appropriateness of the appointment? And I say this with regards to Mr. Ngobani because, as far as I understand, he was disbarred from practicing law in the United States of America. So was there no internal process that would say this is not an appropriate appointment?
No, Honorable Heron, I wouldn't say there was a process for such, because I think the instruction would have come after that has been given a thought.
Sorry, after?
After the issue of appropriateness is given a thought.
No, I'm sorry, I don't understand the question, the answer. My question is, when you are giving names or someone is giving names to the attorneys appointed, is there no process where those names are considered for appropriateness, regardless of Mr. Ngobeni's past, anybody? I mean, if you decided to appoint Brett Heron as an expert on reserve banks or central banks, I would not be an appropriate appointment. Is there no process to assess the appropriateness of the appointment?
No, there's no process. That will
So
be
it's just a name, and if you're happy with that name, or it just that person is appointed, regardless of,
yes,
of any assessment.
Yes. So what I was trying to explain is that when the instruction comes to me, I believe the person who gives the instruction has already made an assessment whether the person is appropriate enough to actually render the service.
Thank you. My last question, Chair. When you were last year, Mr. Sithole, there was some evidence led that the public protector was involved in suing for defamation after she'd been called a spy. And there was some uncertainty as to whether the Office of the Public Protector or the acting public protector had withdrawn legal services for that case. Has that been clarified, or can you tell us whether that has happened or not?
I don't think it has happened, Honorable Harold.
There hasn't been a withdrawal of legal services for that case?
No, and since Advocate van der Merwe come in, he can perhaps clarify that position.
Thank you. Thank you, Chair.
Thank you.
Thank you, Honorable Heron. Honorable Mylam.
Thank you, Chairperson. Good afternoon, Mr. Sithole.
Afternoon, Honorable Mylan.
I'm sorry, you're muted, sir.
No, I'm not. Can you hear me?
I can hear you now. Yes, thank you. Mr. Sithole, do you have any media qualifications or communications qualifications?
No.
Are you a communications expert in any way?
No.
Can I ask, Chairperson, that the evidence leaders flight the invoice of Sianejo attorneys, the one with the 2 articles that are listed? Okay, if we scroll down a little bit, you'll see there that it says, looked at published articles. If we scroll down a little bit more, researched, drafted, and published an article on Mbaweni's attack on public protector and judicial review. And then if we scroll down a little bit more, it says researched, drafted, and published articles on State Security Minister's attack on public protector, constitutional mandate of public protector, and apartheid. And it's signed Paul M. Ngobeni. I believe that's Paul Mpande Ngobeni, who is the person that was appointed here. Is that correct?
Correct.
Okay. Now, where does that fit into a legal opinion?
My response to this is that we must start with item 1.
No, I'm sorry. I'm sorry. I don't want to start with item 1. I want to start with the item that's on the screen there. Researched, drafted, and published article on State Security Minister's attack on public protector. How does that fit in with a legal opinion?
I will request to go back to my answer in respect of the context of my involvement in respect of this invoice. And I'm saying if we go to the first 2 items, they refer to the drafting of an opinion.
Okay, can we go up?
That was my response in response. I mean, that's my response in relation to this specific invoice. So, so if you look at item 1, 2, and 3, those speak to an opinion, those 3. And then the following ones are the ones that will then relate to publishing of articles. I think it's the last 2 items that Honorable Mayland referred to.
Okay, that's fine. First of all, with regard to what Honorable Gondwe was asking, we've established that Mr. Ngobeni is not an advocate. He's not an attorney. He's not registered with the Legal Professionals Council or the Legal Professions Council. He is in a report of the Public Protector, which has not been set aside, described as a fugitive of justice. Now, that is a 2012 report of the former Public Protector. On what basis would he have been appointed to, first of all, provide an opinion, and secondly, to provide communication services to the Office of the Public Protector?
Thank you, Honorable Mayland. As I've stated, the instruction to appoint counsel came from the late Mr. Nyembe. And as far as I know, when I came into legal services, Advocate Ngobeni had already provided an opinion on the appointment of special advisors. That was before my time. So when I came in, I only knew him as Advocate Ngobeni. And on the instruction, it's that please appoint Advocate Ngobeni to provide an opinion on this and that, and then he was appointed on those bases. But as to why perhaps Mr. Nyembe believed that he was credible, I wouldn't comment or know.
Okay, let's stop referring to him as Advocate Ngobeni, because we've established that he's not an advocate. That's the starting point. But let me come back to that invoice. If we could just put it back up on the screen.
Just a pause. Advocate Bauer.
Can I maybe inquire as to the starting premise as to whether he is an advocate or he's not an advocate, because I don't know that. So I'm not sure how Honorable Milam has established that.
I checked on the LPC website.
And maybe as a point of clarification, not all advocates
Okay.
are necessarily.
Okay.
So I'm not disputing whether he is or isn't. I'm just not sure.
Okay, I withdraw that. I withdraw that statement.
No,
Chair.
no, thank you, Advocate Bauer. So we've not established that yet, Mr. Myler.
Okay, fair enough.
You might carry a view, which is fine.
That's fine. I'd like to just, if we scroll down, you signed off on this on this invoice. Is that correct?
Yes.
And you paid Advocate or Mr. Ngobeni. Can we just see the amount that he was billed there for those 2 articles?
I think it will be at the top.
No, it was on our invoice. 97.
It looks like 87,000 Rand amongst other things for the 2 articles.
No, that's
Now-
not for the 2 articles.
I'm sorry, I'm looking at
Oh,
the
is-
figure
is-
of 80.
Okay. Sorry, Honorable Milan.
Sorry, the figure that appears is Mr. Ngobeni's fee, 87,000 Rand. Am I incorrect in that amount?
No, you're
Just-
correct.
just a
You're
pause.
correct.
Just a pause, Advocate Bauer.
Sorry, Honorable Mr. Malami, if I can assist you. The invoice of Mr. Ngobeni shows 43.5 hours, which translate as the rate of 2,000 Rand an hour into 87,000 Rand.
Okay, so it was 43 hours, which translated into 43 and a half hours, which translated into 87,000 Rand. And if we could just go back down, see how many hours were billed on those 2 items. So it's 11 hours and 6.5 hours. So that's 17.5 hours. So that's 17.5 times 2,500 Rand. That's nearly 30,000 Rand for 2 articles. Is that correct?
Yeah, I think that's a correct round figure.
Okay, that's a good rate for writing an article, but we've already established that you're not a communications expert, and I'm still not clear what authority you have to pay for articles, not opinions, not legal opinions, articles that are published in an online publication.
Who's got that?
But just a pause before he answers. Advocate Mbofu, you have your hand up.
Yes, thank you, Chair. No, I mean, the questions are misleading, and I'm not sure if it's deliberate or not. But can we just show that the full item, because Honorable Malham stopped reading on the item at the point where it doesn't fit with his theory. Can you put up that invoice? Further down. Yeah. Yes, okay, yeah. The first one, it talks about, no, that's the second one, research and further down, sorry. Yes, that's the one that Honorable Malham read up to the word attacks on public protector, yeah. And he left out deliberately, I think, the constitutional mandate of the public protector and apartheid era classification of document issues, which I don't know if he also says that's not a legal issue. And I suspect that's why he didn't read that part. So let's ask if we are.
Sorry, Chair, I must object here, Chair.
No, but let me
I'm objecting on the basis that, can I please, Mr. Mpofu, Advocate Mpofu?
Yeah, but can
I'm
I finish
objecting
talking?
on the basis,
No, but
Advocate
can you
Mpofu.
finish talking?
Advocate
Don't
Mpofu.
interrupt me. Don't interrupt
Advocate
me.
Mpofu, you interrupted me.
I did not interrupt you. I asked the chair for permission.
Honorable
It's the
Mylan.
chair who
Honorable
really,
Mylan,
Chairperson,
just
please.
pause, Advocate Mpofu.
Thank you, Chair.
If you object, you must allow the chairperson to allow you to object. You can't just proceed because you're objecting. So I would like you to wait for Advocate Mpofu to finish, and then I'll hand back over to you. Advocate Mpofu, proceed.
Thank you very much, Chairperson. Yes, I avoided interruption by putting my hand up deliberately, but thank you. No, I'm saying, Chair, that it's important, just as a general principle, that the questions must be fair and not be deliberately misleading. And my objection is based on the fact that the previous question, in my view, was deliberately misleading insofar as it left out the full item, because there's no point in saying so many hours, but you've only read one part of the item, because then the witness obviously is going to say yes, 30,000 for, but the 30,000 is actually for the quarter that Mr. Mylam has read, not for the full thing. So let's just not mislead the witness. We'll still get the same.
Okay.
Thank you, Chair.
Thank you, Advocate.
Can I now raise my objection?
Thank
Chair?
you, Advocate Mpofu.
Thank you, Chair. I'm done.
Chair, can I now raise my objection?
Yes, Honorable Mylan.
Chair, I object to the fact that my question is being referred to as deliberately misleading. I have not deliberately misled the House, and I request that Advocate Mpofu withdraw that. I asked a question because the invoice says, and it reads quite clearly, if you put it back on the screen, it says that researched, drafted, and published article, and then it gives a long title. And then it says at the end, after the full stop, published at. And there's the whole, so the whole piece there is not about a legal opinion. It is about an article that was researched, drafted, and published. And so I would request, Chairperson, that Advocate Mpofu immediately withdraws the suggestion that I was deliberately misleading this House.
No, Honorable Mylam, I'll turn to that. I want you to continue with your question, because the point he was raising was that you did not read the full.
Chair, he did say I was deliberately misleading.
I got that part, but I think his emphasis is reading completely everything else. I wouldn't want us to spend time on this. You're on the.
Thank you, Chair. So my question to Mr. Sithole was, on what basis, what authority does he have to sign off on communication?
Thank you, Chair, and Honorable Maylen. As I stated, Honorable Maylen, the first 3 or 4 items relate to the rendering of an opinion. And if you look at the 2 items that you query, they relate to the opinions in which we sought Mr. Ngobeni's services. But I wouldn't want to take it to an extreme and say that that invoice only related to the publishing of an opinion. If that was the case, I will not have had any authority whatsoever to process that invoice. So for me, my response is the first 3 to 4 items relate to the rendering of an advice.
And the last 2 items were outside of your scope of authority?
That is not rendering of an advice, it was a publishing of articles.
I'm sorry, I didn't understand that. It was not relevant to?
So it's publishing of articles, it's not rendering of a legal opinion.
So publishing of articles is not rendering an opinion?
Yes.
So then how can you pay for it?
I paid for the opinions.
Yes, but part of that invoice was not opinions. You've just said that the last 2 items were not rendering an opinion. So how can you then pay for it?
Yeah, maybe let me repeat. Maybe advocate, Honorable Malian, if I may repeat, if you check the articles that are referred to and you check the first 3 items, they relate to the same issues. So I will say, this will be my view, that was probably a value add to him rendering an opinion. That will be my view. That to say to publish those articles in relation to this, that will be a value add to him rendering an opinion on those.
If it was a value add, Mr. Sithole, with the greatest of respect, if it was a value add, there would be
It's
a
going to be
zero.
the last point you make.
There would be a 0 hours next to it. If it was a value add. But the fact of the matter is that he billed 11 hours and 6.5 hours for publishing articles attacking government ministers for their positions, their statements about the public protector. Now, again, how does that relate? How do you, Mr. Sithole, who signed off on that invoice, who paid that account? You know, if I get an invoice and I dispute something on it, I send it back and I get a corrected invoice. If these 2 items are outside of the scope of my authority, I'm not going to sign off on it. So how do you justify signing off on 2 items that are not within your scope of authority?
Yeah, that's why I'm saying that was probably a value add, and value add not in the sense of monetary terms, but in the sense of an extra service that this person gives you over and above the principal service which you sourced him for. So maybe let me put it this way. I don't think you will want to appoint him to give you an opinion and then separately appoint him to draft 2 articles that relate to the same opinion on which he gives you an issue with. But Chair, I must not be difficult also to Honorable Malian and say to an extent that that should have come separately, and we should not have processed those specific 2 items. I will agree to the extent that it sits at my door because I had signed off that invoice.
Honorable Mananiso.
Okay, thank you, Chair. Dumelang, Tate Samuel. Muntu Sithole, excuse me.
Dumelang.
Busy. I think, Chair, let me put it forward to say that on other issues with regards to Mr. Ngubeni's services, I'm covered by Honorable Gondwe and Aaron. But my follow-up question to Mr. Sithole, it's, do you agree that there would have been no need to engage him through Sianego attorneys if he was not a practicing advocate?
Please repeat, Chair.
Oh,
no, you can repeat in English.
Just repeat in English for record.
No, I don't want to repeat English. With what it's been said or questioned to you today by other members with regards to the services Ntate Ngubeni, sentle Ntate Ngubeni nasa tshwanela go patelwa jaaka advocate or under Sianego attorneys.
No, I think context points to the contrary in respect of the opinion. And I understand the issues that are raised by the honorable members in respect of the issue of articles. But in respect of the opinions, I wouldn't say that was wrong.
Okay. And then let me go to your affidavit. On your affidavit, you have indicated your responsibilities or duties being given to you at the PPSA. So I want to ask you this question with regards to your understanding and experience on administration, governance, and leadership. do you think that the PPSA, where it is now, there's a need of organizational behavioral change?
Maybe if you can expand on that, Chair, on the issue of organizational
Behavioral
change.
change. Okay, my explanation is like with what it's been said by other witnesses and things that has been happening. For example, you have alluded on the issue that there's no proper filing. So in an organization like PPSA, you don't need to experience such because of you've got best human capital that would actually know the basic on putting those systems in place. So hence I'm asking that in terms of whatever that we have, listened to in this particular PC, is it important that the organization itself go through the process of changing some of the cultural behaviors within the organization? That's what actually I was asking about.
Thank you, Honorable Member. I don't think the problem, maybe to dwell on the issue of record management, I don't think it's necessarily poor record management which will need a behavioral change, but it's the issue of record keeping, such as insufficient storage, such as a proper filing system that the institution has. It's an organizational administrative need, which I think the organization is currently embarking on a process to rectify that aspect. But I wouldn't put it as a poor record management individually by the investigators or incompetence in terms of record management. And as I've stated, I've given an example that the investigators actually sit with files, some of which date as far back as 2016. They sit with them in their office because we don't have storage. So there's no proper filing systems, if I may put it that way. So if you mean there must be change, it's not necessarily behavioral change, but systems must be put in place to ensure that there's proper filing and record management.
Okay, but I think as the person who is in charge of such institution, you need to explore on what is the organizational behavioral change, because in your organization, there's so many things that are happening with regards to how people are being treated and others who feel that they are mistreated because of the proximity with the PP. So in future, because you've got a future, bright future ahead of you. Chair, and the other thing that I want to ask Mr. Sithole, it's if you were given an opportunity to speak about the leadership style of the PP, what would you say? Because the nice thing that I've noted when you were questioned about how she is, you were so excited about telling us that
let's stay on the question.
Okay.
What's the question?
She has a sharp mind. So I just want you to tell us about how is her leadership skills. Chairperson, don't intimidate me.
Thank you, Honorable Member. I will say PP is results driven, and if she sets a target, she will go out of her way to make sure that that target is met. And I've also been at the receiving end of not meeting some of her targets at legal services, and I don't think it's something which I can say it's out of the ordinary. It's something that any PP will do actually, especially when it comes to a highly charged environment such as ours. So for me, I would say if there's one word that can summarize her leadership skill, is that she is results driven, and I think we all are.
Chairperson, my last question. Mr. Sithole, on your response to the leading evidence leaders, you took us through that actually as the office, you don't actually follow the normal supply chain management procurement processes. So I want to check with yourselves to say whatever that you are using as the process to identify service providers, is it supported by any legislation perhaps that you can relate us to? And if not, why? Thank you. That's my last question, Chairperson.
No, I don't think we said that. I think probably the honorable member refers to appointment of counsel. We have a procurement process for appointment of attorneys who are in the panel of our attorneys. And we don't have a procurement process for appointment of counsel, which I think the institution is currently considering putting that in place. So yeah, I will say in respect of counsel, there's no procurement process because we source their services through attorneys, and attorneys
you.
are appointed in terms of the procurement process.
Thank you. Honorable Ngozi.
Thank you, Chairperson. Good afternoon to you, Mr. Sithole.
Afternoon, Honorable Ngozi.
Thank you very much. Mr. Sithole, you will know that the Office of the PPSA is a Chapter 9 institution, isn't it?
Correct.
Therefore, it can do nothing that is in the Constitution, in your enabling legislation, in your standard operating procedures and SCM.
Correct.
Okay, thank you. If that is the case, Mr. Sithole, when you joined legal services, did you, one, thoroughly examine the MOU between you and Sianego attorneys?
I'm not sure if I get, there's no MOU between us and attorneys.
When you brief them, you just brief them. You don't get into an undertaking that says we are briefing you to do 1, 2, 3, and in 1, 2, 3 you can do only one.
Yeah. So in the letter that I referred to earlier, we will say we appoint them to render which service. So it will be specific. It will not be all encompassing.
All right. Did you do any due diligence in respect of counsel that Sianego engaged? In this instance, Mr. Ngobeni.
Did we do due diligence on Advocate Ngobeni?
Yes.
Myself, no.
Did you check? In other words, did you check if, one, he is qualified, two, if he has any criminal or any other record against him, two, if he has rendered any opinions before, and as an organ of state, if he appears in National Treasury's records as a service provider?
No.
And you proceeded to pay him irrespective of that?
We paid him for the services he rendered.
Yes, I know you paid him for the service he rendered, but there's a first step. The first step is to check whether this person, in terms of your due diligence, one, has the capacity, two, is he properly qualified, three, does he appear on a list of service providers with National Treasury?
Honorable Nkosi, I think in my previous responses I've stated that we appoint the attorney, then the attorney appoints the counsel, in most instances on our instruction. So Advocate Ngobeni, Advocate Mpofu, Advocate Bauer will not appear on the list of National Treasury as service providers because they render a service on third-party basis. So they are appointed by attorneys to render the service. The attorneys will be on the panel of attorneys, and they also will be on the CSD, a National Treasury database. So you will not look into that in respect of service of professional services.
And then, but you, despite that, you continued, despite not knowing the background of this fellow that is being used. So if I'm appointed and I'm a criminal, it doesn't matter to you. Or I've got a criminal record, it doesn't matter to you as an institution of state, as an organ of state.
Honorable Nkosi, I think that will be incorrect. But as I've already stated, when I joined legal services, Advocate Ngobeni had already rendered one, if not two, legal opinions. And then when I was instructed to instruct attorney to brief him, I came with an assumption that he is indeed an advocate. I didn't do any due diligence, as you put it.
It was an incorrect assumption in retrospect, isn't it?
I wouldn't say so, because he did render those opinions.
I'm not asking whether he rendered or he didn't. I'm saying from the onset, this person is incapacitated, is not qualified to give you a service because of impairments that he suffers in his profession. From the onset, so it doesn't matter whether he continues to do. In fact, when you continue to use their services, you are continuing an illegality. Am I not wrong?
You are wrong, Honorable Nkosi. As I've already stated, he did provide legal opinions, and those opinions were made available to the members. And then whether the opinions are correct or not, it's a question for another day. But for me, he was appointed to render an opinion. And as I've stated, and I think the previous member asked if we have a system in place where we enter into an agreement with advocates. We unfortunately do not. Therefore, if maybe that process was in place, we would have then probably have terms that we put there to say, if you appoint an advocate, it must be someone who belongs to this bar. He must have this number of experience as an advocate and blah, blah, blah. So there was no specific criteria that binds us to the appointment of an advocate. I am not sure if Honorable Nkosi is answered.
So you continued, so you appointed him despite the fact that you are not allowed by the Constitution, by your own founding legislation, and your standard operating procedures and SCM.
No, we are not restricted by any of those pieces of legislations you have mentioned.
All right. My next question, Chair, relates to evidence was led here that at a particular point in the service of Advocate Mkhwabane, cost-cutting measures were introduced, which resulted in other aspects of the PPC's work not being achieved. And these funds were then surrendered or suspended to legal services. Are you aware of that? In other words, your budget as legal services increased at the expense of other programs, particularly outreach. Are you aware of that?
Yes.
Were you not surprised that all of a sudden your budget is just increasing?
No, Honorable Nkosi, the context is incorrect. Our budget was not increasing. It's only that the institution could not commit funds to other programs because the expenditure will then constrain the overall budget of PPSA. So it was more of a strain than it was of taking from one function and bringing it to legal services. I think if my memory serves me well, we always got assistance from the Department of Justice whenever we exceeded our budget.
But that's not the evidence of other people who came before you.
That's
The
their
other thing, Chair,
evidence.
is that, it's not their evidence. Their evidence is that money was taken from other programs to legal services without even asking for treasury environments and permission to do so. But anyway, my next question, Chair, is
No, not anyway. Chairperson?
Just pause, Honorable Ngosi, Advocate Mbofu.
Yes, Chairperson, is the same issue that I'm raising. We must all refrain from misleading the witness. Who is this person who said money was taken from one budget center or cost center and put to another? There's no such person in this inquiry. So please, let's not mislead the witness. Ask questions and you can put them as biased as you like, but don't mislead the witnesses. Thank you.
The Advocate Mbofu, Honorable Ngosi.
Chairperson, it was Mr. Samuels.
Over to you.
But yeah, it was Mr. Samuels. But Chairperson,
Mr. Samuels didn't say anything like that.
No, Advocate Mbofu, please don't do that.
Okay, Chair. But it's not.
Thank you.
It's
yeah, can I be protected, man, from this onslaught?
Yeah, no, I'm trying to do that. Please continue, Honorable Ngosi.
The other question to you, Mr. Sithole, is the following. Is it normal practice for you to obtain services of external service providers to prepare your inputs for the portfolio committee?
I wouldn't say it's normal practice because it was for the first time that we had to make submissions in respect of the rules.
Sorry, in respect of?
Meaning it's for the first time that we had to start the process that leads to where we are now. So I wouldn't say it's normal practice.
So you didn't have the capacity inside to as legal services to do the same?
We assisted in addition to sourcing external services.
Okay. Chairperson, my last issue relates to the following. In one of your comments you make the comment that you think in relation to a particular case that the judge was sitting with the DA next to them before, something to that effect, before they arrived at the decision. Do you consider that as an appropriate comment to make?
No, that's a wrong comment, but it was made to the PP. And it is me who made it to the PP. It would have been a different story if the PP made it to me, because the impeachment is about the PP, not me.
No, I'm asking you, is it appropriate?
I'm saying it's incorrect.
Of you to say so?
Yes.
Okay, thank you, Chair.
Thank you, Honorable Ngosi. Members and colleagues, we will now pause there. The time is 1:20 and go for lunch. We would also not resume in the afternoon, given the 3-line whip house session. We'll convene tomorrow at 9 a.m. Advocate Bauer, you want to say something?
Yes, the witness made mention of having provided me with opinions on Friday morning, and I only saw this after he gave evidence. He had it just about 9 o'clock afterwards, sent me the opinion provided by Mr. Ngobeni, and I don't think I uploaded it or it was made available to the members, but I'll certainly do so now. And that's the only opinion of Mr. Ngobeni. And if we are reconvening, I do not have or have not been provided with any fee notes of any other opinions that have been rendered by Mr. Ngobeni. If Mr. Sithole could find those for us overnight, that would be good.
Okay, thank you, Advocate Mbofu.
Thank you, Chairperson. Sorry to come in now. No, I was just worried. I thought Advocate Bauer was going to intervene because she has a very packed program. And I wanted to check whether if I don't know how many more members you have, Chairperson, if it's not possible to just take a few more minutes and rather finish this witness. Otherwise, we're never going to finish on Saturday. I'm in your hand. I know that the members go to the house and all that jazz.
Yes,
Yeah.
thank you, Advocate Mbofu. I've taken that into account. So we just have 2 more members, which will quickly deal in the morning, and we're done with the members. We're starting at 9, much earlier than
unusual. Yeah.
Scheduled.
Okay.
Thank you very much.
Okay, thank you, Chair. I was going to say we should start at 8:30, but I think 9 is fine.
Chair, I'm awaiting a ruling on my objection, my point of order that I was accused of being deliberately misleading. That's unparliamentary, and I request that be withdrawn.
I declined that.
Sorry, Chair, you said you'd come back to me on it.
I declined that.
You declined the fact that I was being deliberately misleading.
I tried to explain what he was trying to do. So I'm not making a ruling on that. I did try to explain to you that this is what he was emphasizing on.
Chairperson, I reserve my right to write to the Ethics Committee, the Rules Committee, whatever is appropriate.
Thank you, Honorable
because
Myla.
I'm glad Advocate
we
Mbofu finds this very
adjourn.
funny.
Thank you, Chair.
The meeting is adjourned for tomorrow, 9 o'clock.
Thank you, Chair.
Recording stopped.